Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not
To a grand jury.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case. Dati mihi Anglican employees, verbis Latinus.
Is that correct?
Literally not true. I didn't ask you to interrupt me. Oh, for crumb's sake.
All right, welcome back to the Court of Public Opinion. I am the Recovery Addict. Good to have you here. I'm sorry I was a little bit late, but there was something going on in another courtroom that I needed to watch.
Remember in the beginning when we started 110 years ago?
And I hate to do this to you, but I can't show you what it is. It's one of our favorite courts. I just can't stream it. The language would get me banned on the tubes, on the YouTubes. It would get, well, not necessarily banned. It would get me demonetized in a heartbeat. But Judge Middleton is having the day of his life. He's learning all about cats and dogs, and the racial slurs are flying. Wow. Yeah, so no, we're not going to. There are some words that just don't get said, and they're being said in his court right now. So, landlord-tenant case went upside down and beyond. So there's that happening. I've been watching it. I had to pause it to watch later. Yeah, if you've seen it, you know. Whoa, wow. It's just great. And oh yay, on lunch. Hey, thank you NBC for the copyright claim on Corey Richens' trial. So I'm going to be disputing that one as well. Fun. All right, we're almost. Let's go back to court, shall we? Not that court, not this court, which is this one.
Like that's what I do.
No, not that one. We're going to go to this one. Okay, we don't want to risk anything being said. That would be problematic for the channel. And well, we're here. Kim R, congratulations, first in chat this afternoon. Your promptness is going to be punished. Internet ownership is your punishment. So. You know the drill. You've won before. Yeah, I need to. I wish I had saved what I wrote for Netflix, because it's a different episode, but it's the exact same reasoning. So apparently they're saying they own the whole thing. Right. And my channel's not even monetized.
Hello?
It's not. My Top Mark Media is not even monetized, and they're filing a claim on it. I'm like, no, you don't do that. So, all right, let's see. We're about to come back to court. Where are we? Oh, we are. We are back to court. Where are we going to pick up? We're going to pick up with the witness who is going to be answering some questions. The lawyer is taking his, he's ready. He's ready to rumble. He's taking his jacket off. Coming back with the witness on the stand who's going to testify about the 911 call and whether or not he said there was a firearm involved at the time he made the call, or whether he denied there being a firearm involved at the time he made the call. Now, years down the road, he's remembering the firearm, possibly multiple firearms were used. So he's also said that he doesn't remember because it's a couple of years ago. So we'll see what happens. It's going to be, it's probably going to be spicy as we get to the end of this. All right, sent some pictures. Texan, thank you very much. We showed the courtroom earlier. I appreciate that. All right. KLB, we are scared to death of that right now. It literally keeps me up at night. So, because there doesn't seem to be rhyme or reason to it. That's the hardest part. I mean, if there was something people were doing wrong and you could correct it or fix it or not do it, that would be great. But just I mean, random channels appear to be disappearing, and there's no. I don't understand how they're deciding which ones stay and which ones go. All right. Hopefully we'll get that sorted out. Okay. Okay, court staff is coming in. Welcome, ma'am. Have a seat. We've got the defendant. Let's put our jackets back on. Nice. Get dressed for court. Sleeves are hard, sir. I know. It's tough. Yep. There we go. Fix the collar. Make it pop. Nice. Looking sharp. Okay, we're just waiting for the judge to walk in. We'll know she gets here because everyone will just pop up a little bit. We do see Texas there in the court. Welcome, Ann. Texas Ann. Texan. I like that. That's a good name. It's a really good name. All right. It's time, Judge. It's time. If everyone could just get started on time, it would be great. I know I'm late, but if they could start on time, it would be great. If anybody's looking for some homework to do in the meantime, in between times, there's our witness walking in. If you could figure out how to make a TGA file or a series of TGA files so I can use them on my switcher using DaVinci Resolve Studio, let me know. I can't quite figure it out. Used to be there. It's just not working now. There we go. Judge is here. And let's begin. I'm glad the witness came back. I was worried. Judge is doing some paperwork, maybe? What's happening?
All right, let the record reflect state's attorneys present, defendant, and defense counsel are present. Anything we need to do before we bring the jury in?
Not from step. Judge, do you want to address the charge now or wait until after?
Let's wait till after. You can bring the jury in. And y'all all got the newest email with that in it. Do either of you want me to print a copy when it's time to work on it, or y'all?
No, Judge, please.
A TGA file. They're a series of still images. I think stop action photography, but it's a digital file used to create a, like, you remember when you watch the news and down in the corner it says like, this is Fox 13, and the Fox 13 just rotates. It's just on a repeat and it rotates and rotates. It's that. It's a series of files that make that moving image. Those files, those 400 still images are played over and over and over to repeat a 10-second clip. That's what it is.
We don't technically put this court's copy in this chapter. We don't really need it.
It's like a flip book, but for
I think we did.
for video
That's
switchers.
fine. We'll do it if I did. I think we talked about it when we were. Yeah, okay. It's not gonna hurt anything to have them. Dan?
All right, that is the jury. Yeah, they do show them in this court.
All right, let the record reflect the jury is seated, state's attorneys present, defendant and defense counsel are present. Mr. Wilkerson, you may continue.
Thank you, Your Honor.
See if we start spicy or if we build up to it.
Cooper, are you the same Daryl Cooper who either does presently or used to live at a house on Pine Street?
No, I've never lived on Pine Street.
You've never lived off of Pine Street, right off of it?
I lived on East Gill Street.
I'm sorry.
I lived on East Gill Street.
Very near the corner?
No.
No?
At the bottom of East Gill.
Okay. Before we took a lunch, I'd asked you if you recalled making some statements. When you spoke with the 911 operator, isn't it true that you told her first that you didn't know what they had?
Yeah. At that point in time, that was seconds after I got right.
Objection on the
So just answer the questions that he's asking you, and the state will have an opportunity to follow up.
Isn't it true that you told the 911 operator you didn't know what they had?
I don't recall.
We're going to play the tape then.
So, Mr. Cooper, you listened to that recording with Mr. Wilkerson over the break, correct?
Okay, right.
So you were able to reflect the memory about what you did or didn't say on that recording, correct?
Yes.
Okay, so just answer the questions based on what he's asking you. And again, if there's any explanation, Mr. Coleman will be able to ask you about any follow-up, okay?
Okay.
All right.
You've told the 911 operator that you didn't know what they had, didn't you?
That's what I said on the frame.
Okay. And you had the wherewithal to tell the operator that the individual who was not Mr. Johnson put his or had a bag that he pointed at you with, right?
Right.
And you testified that you were drugged. You were also asked if you needed EMS attention, right?
Right.
Which you ultimately refused, right?
Right.
And y'all spent, would it be fair to say you spent more than 2 minutes on the phone together?
With the
911 operator?
Maybe. I didn't have my watch on.
Well, I'm asking because I understand you to be attempting to assert that you were still in some kind of shock or trauma associated with this interaction, right? That you couldn't think to tell the 911 operator that there were firearms or that there were weapons involved, right? That's what you're saying?
Well, I knew the police were coming. That was is the police officer here? Have he written down everything I told?
All right. Mr. Cooper. Well, hang on, let me trace it. Mr. Cooper, you were convicted in 2024 for theft of property, a state jail felony, correct?
Yes.
And that conviction included the fact that you had 2 or more prior theft convictions, right?
Right.
And that's why it was a felony, correct?
Yes.
All right. In conjunction with that case being adjudicated, a separate criminal mischief, also felony, was dismissed, correct?
What's this have to do with Mr. Romeo?
Ask the witness to be instructed to answer.
Judge, I would object to that because that's not proper impeachment. That type of an offense is not proper impeachment.
Sustained.
In 2018, 19, you were convicted of a Class B theft, correct?
I guess so.
And in 2018, you were convicted of a Class B theft, correct?
Okay, yes.
And going back to 2000 and in 2010, you were convicted of a felony offense, correct?
Am I being charged again with it?
Ask the witness.
Sir, just answer the question.
Yes.
And then just prior to that, in 2007, you were convicted of the misdemeanor of burglary of a coin-operated machine, correct?
Correct.
Isn't it true that you and Mr. Johnson, for a number of years, hung out together?
I've known him.
You've known him? Has he spent time at your house?
A lot comes to my mind.
I asked the witness to be instructed to answer the question.
Answer the question.
Sir, I'm 65 years old, and that house was given to me when I was 37. So I don't recall that when it came by my home.
You don't know if the defendant ever came to your home?
Really, I don't.
Well, let me ask you this. In terms of the defendant coming to your home, would he have reason to come and hang out there?
Sir, as I said, I don't remember who all came by my home.
What I'm asking you, sir, is there some purpose for which he would have came and hung out there?
I would object to the relevance.
I suppose the same thing.
Hold on.
I object to the relevance of any prior visits to this residence house. Okay?
Well, he said he doesn't recall anyways. It's been asked and answered.
You were asked earlier if you had wanted to be here. A writ of attachment had to be issued to get you here, didn't it?
Not good, sir. You have to understand with me. I work. I had my leg contact.
Objection.
He asked me a question. Can I answer, ma'am?
Well, you're not answering really the question he asked. So he asked.
The reason being why, because I got robbed.
Hold on. Yeah. You have to answer just the questions he's asking you. I know you want to explain more, but that's not really the way it works, okay?
Okay.
Thank you, sir.
And back when you alleged that the defendant robbed you, was your foot broken at that time?
My foot was never broke, but I got hit by 18-wheeler. I was dropped, but have no control over when I walk. I have to be self-concerned where I'm going when I walk. Maybe right step, turn for left step.
When did that happen?
May 26th of 80. I'm disabled.
And it's your testimony that you never borrowed any money from the individual who was with Mr. Johnson?
Absolutely not. Absolutely not. I have money. I work every day. I have cash every day. That's why I got robbed.
Okay. Why were you staying at the hotel?
Objection. Relevance.
Your Honor, I believe that this will explain what was going on that led to the exchange between, that led to the allegations that the witness is making that this defendant robbed him.
Overruled. You can answer the question.
Was I staying at the hotel?
Yes.
Because I was homeless.
You don't still own the house that you were given years ago?
Of course not.
So you were staying there long term?
Yes. Whether you're short term or long term, I don't see the relevance.
Sustained at this time.
Um, is that particular location a location that where a lot of illicit substances are trafficked?
Objection, relevance to this defendant and the allegations.
Sustained.
This witness subject said.
Pass witness.
Thank you. Anything else, Mr. Coleman?
Just a couple follow-ups if I may, Judge. Ms. Cooper, you made reference to a clicking sound within that bag that you believe there to be a firearm.
Yes.
And when you say click, are we talking about maybe possible racking of a firearm?
Yes.
Okay. Do you have any doubt whether or not this defendant was acting in concert with or together with the other individual when they took you to the ATM to try to get you to force you to withdraw money?
Of course, before and after.
Okay. And regardless of your criminal history or your run-ins with the law, are you here today and telling this jury the truth about what happened that day?
Yeah, 100%.
Thank you, Mr. Cooper. I'll press the witness, Judge.
Anything else, Mr. Wilkerson?
Yes, Your Honor.
This just keeps going back and forth. I'm trying to write it.
You testified that y'all walked to the market basket that night, correct?
Correct.
All right. Did your injury interfere with that walk?
My injury with the injury you speaking of. The leg?
Yes.
Did it interfere? I walked. It was it has no, did.
Okay. So what you're telling this jury right now and here today is that despite all of your other dishonesty in the past, you want this jury to believe that this man robbed you despite you being homeless at the time?
Homeless?
Where'd you get that from?
You said you were staying at the hotel because
okay, that has no relevance. But I told you that you wouldn't let me take. This is why he was upset because they banded him from the property and he could no longer stay there. So he figured that I owe him from him not being able to be there anymore.
Mr. Cooper.
Yeah, that's the truth.
Okay, I understand. Just listen to the questions and answer them, please.
Asked the jury be instructed to disregard.
He asked the question. He opened it.
I'm not gonna, no.
Okay. So again, you're asking this jury to believe that this defendant robbed a homeless man.
Of course.
And if you were homeless, what belief or reason to believe that you had money that the defendant had?
Because I work every
Let's
day.
say, Judge, Judge, this is part of speculation on part of this witness as to what this defendant believed.
This witness testified that this defendant knew that he could get money.
Of course, I work every day. I do headlight research. I have cash on me every day. That's how I was staying at the hotel. They don't let me stay there free.
Objections, non-responsive.
I think he's answering the question.
Was someone else staying with you there?
No.
You weren't sharing a room with another lady.
Maybe sometimes like that you trying to mislead the jury. Look, you asked me a question. I told you I answered it.
But I want you to answer honestly.
And if you ask me each question separately, I would.
Pass the witness.
I have no further questions for Mr. Cooper.
Any objection to Mr. Cooper being excused?
No, Judge.
No objection. Your Honor.
Thank you, Mr. Cooper. You're excused. Keep in mind those instructions you were given yesterday also, okay?
The state has no further rebuttal. Your Honor.
Thank you, Mr. Coleman. Mr.
All
Wilkerson,
We made
any
it.
rebuttal? Anything else?
Any Sir rebuttal?
Just, Officer Carter, sure.
Is he? We can get him here, Judge.
All right, then no, I don't want to make delay any further.
All right.
Defense rest.
Thank you. All right. So ladies and gentlemen, what that means is that at this time you've heard all the evidence that'll be presented in the trial. The next thing is for me to read that court's charge to you. I've prepared it just based on, we need to take a break based on the testimony, make sure we have it all the way it's supposed to be. This shouldn't take longer than 10 or 15 minutes because it's already done. So it's 1:35. I'd like to try to get started about 10 till 2. Please keep in mind all the instructions you were previously given. If everyone else would please remain seated, you are excused for about 15 or 20 minutes.
All right. That happened.
That's not far. Got too much going on. Yeah.
Here we go. Defense attorney said, I don't want to delay things any further. We won't call any more witnesses. I guess we're good. We're not going to call the officer
Mr.
back
Wilkerson.
up. Trying to write my my complaint to NBC right now.
Yes, sir. All right, let the record reflect the jury is outside the presence of the courtroom. You guys are both given a copy of the court's proposed charge. Any requested additions, objections, or corrections that you guys found?
None from the state, Judge.
Yes, Your Honor. With regard to the paragraph under evidence of wrongful acts possibly committed by the defendant.
What page are we on?
Page 3, Your Honor.
Thank you.
First paragraph under that heading references the murder charge and then says you are not to consider that evidence at all unless you find beyond a reasonable doubt that the defendant did in fact commit the wrongful act. I believe they have to be instructed that they cannot consider that in terms of because he has been acquitted of the matter. If they're going to receive an instruction regarding the murder.
Just because he was acquitted doesn't mean they can't consider it.
If it was
right. I mean,
if he was acquitted, then to consider it as a wrongful act would.
Yeah, you can't do that,
be
Judge.
Antithetical to the acquittal, Your Honor.
This is appeal territory, big time.
Judge, I conferred with Mr. Smith about that over at the break. It stuck out to me too.
Okay.
One of the things I considered was maybe saying the state offered the evidence to show that the defendant either possessed a firearm or to show the links between a firearm and the defendant. I considered that kind of language maybe, out of an abundance of caution.
So how do you just presented the evidence and then told the jury not to consider it?
So
it shouldn't have come in.
What's your thoughts then, Mr. Wilkerson, on, I mean, are you asking that I just take it out completely? Because I don't think I want to take it out completely because I think they need to be instructed about something with regard to that offense, right?
It wasn't an offense.
I would not disagree with the court, Your Honor, in that statement, but in terms of.
So what if I change it to?
Technically, there was no evidence put on about the murder itself.
I know.
It was in relation to him possessing a firearm in previous time.
So
No, the previous time, contemporaneous.
Well, a lot of times we don't even include the specific other act. So some defense attorneys ask for it, some don't. Sometimes we'll leave that sentence out and just say,
So just
you
say-
heard evidence that the defendant may have committed wrongful acts not charged in the indictment. And then take out the next sentence.
Yes.
And then put, you are not to consider that evidence at all unless you find beyond a reasonable doubt. And so you're not pinpointing the murder because there was evidence of the aggravated robbery with Mr. Cooper. And I didn't specifically put that in there yet. So if we're going to do one, we need to do both. So it's probably, I would think, better to put none. But what does that help clear up what you're?
I think it does, Your Honor, because I think they implicitly understand that he was acquitted. I think perhaps the mentioning of if you did want to put something in there, such as Mr. Coleman suggested, mentioning of lack of mistake, maybe. I'm not sure what the state cites in terms of that. Those reasons for which that evidence can be considered.
Well, it's a little bit different, I guess, because technically you brought it in first. And so the state really didn't offer it to show anything. And so because of that, I don't know that it would be, I don't even know that, I mean, I don't mind leaving that. The state offered the evidence because they went further into that evidence to show once that door was open, but I didn't allow them to go into that evidence, or it was specifically the murder. And it wouldn't have been the aggravated robbery charge either. So both of those really kind of came in.
And I think I think then the court's idea of
just taking
removing that sentence altogether would probably be the best way to.
I've done that. Was there anything else?
Your Honor, we had requests. Well, we had previously requested. We had informed the court of our intent to request an instruction on voluntariness of the, for what lack of a better term, the alleged confession.
So I think because Mr. Johnson again took the stand in this case, you specifically questioned him in this case about his taking the stand in the prior murder after advice from you, that I don't know that there's any issue with voluntariness. I understand that your position that he wasn't being questioned specifically, it was a murder case and not the other, but the murder case, by the nature of the murder case, had to do with a weapon. And so did the actual video and everything that came in that everybody knew about in that trial. So I'm not going to put an instruction in on that. I have also already, for appellate purposes, if necessary, put in Court's Exhibit Number 1, which does show that admonishment that you and I both talked to Mr. Johnson about in that prior case. So that's in the record for appellate purposes only.
And otherwise, Judge, nothing else from the defendant.
All right, so I took that one sentence out. Let me, do either of you want me to print a final copy for you?
No.
It's just with that one sentence out? Okay.
No.
Print one for myself will be, we have got about 5 minutes if anybody needs a quick break.
All right, quick break. I don't like it. I don't like it. 100% guilty. It's going to get interesting. Lolly, I feel that. I wish this had been covered by a different judge who didn't have the prior case. And it's possible that this judge looks at that prior case and says, He should have been found guilty. The jury got it wrong. But you can't carry that into this case. You can't. You can't. And the way the objections have been cited, just so much in favor of the prosecution. And I think enough that if he gets convicted, I think he has serious grounds for appeal. Yeah, I'm sensing a bias here with outside information. And it's possible she's right. Right? It's possible the jury got it wrong, that there was enough evidence to convict. At a bench trial, he would have been convicted in a heartbeat. But 12 people acquitted him. And that's the law. And you have to let it go. And this guy might be the scum of the earth. Honestly, he might be the scum of the earth. He might have done everything they're accusing him of and more. And it would suck to have a guilty guy walk free, but that's what we say. It's better that 100 guilty men go free than an innocent guy goes to jail, right? But it's our system. So I'm going to argue for this guy because I don't think the state's proven it in this case. I just don't think so. Yeah. Okay, I'm writing my complaint to NBC right now. We filed for and were granted pool media access with 3rd District Court Judge Richard Mrazek to record and live stream the entire Cody Richardson's trial proceedings. I have documents on file with the court as well as communications from the Utah Court Commission's communications director. That's her name. Providing the details on the connections needed to access the pool feed. Pool media access grants. Pool media access grants members Pool media access grants participants equal, non-exclusive rights to all pool media footage. Only the copyright owner or their legally designated representative may file a copyright claim. Filing a copyright claim for content you do not hold the copyright on violates YouTube policy. How am I doing so far? Don't like it. Yeah, I got a Top Mark Media, my parent company, which is not monetized even. Literally, it's not monetized. I got a copyright claim from NBC on, I think it was day 8 or something, on the whole thing. Should I get aggressive? No, probably not. Probably shouldn't go into bad faith or anything else.
All right, we're back on the record. State's attorney's present, defendant and defense counsel are present. How long would you request for closing?
10 minutes on the high side.
Mr. Wilkerson? 15?
Hopefully, yes.
15. Okay. All right, you can bring the jury back in.
Almost done. I'll be focused again, I promise.
Mhm. All right, let the record reflect the jury seated, state's attorneys present, defendant, defense counsel are present. At this time, ladies and gentlemen, I am required to read the jury charge to you in full. And so pay attention, and then you will hear from the closing argument from counsel. Cause number 25, DCCR 1626, the state of Texas versus Romeo R. Johnson, aka Romeo Randolph Johnson. Members of the jury, the defendant, Romeo R. Johnson, aka Romeo Randolph Johnson, stands charged by indictment with unlawful possession of a firearm by a felon. The defendant has pleaded not guilty, and you have heard all the evidence. The parties will soon present final arguments. Before they do so, I must now give you the instructions you must follow in deciding whether or not the state has proved the defendant guilty. You will have a written copy of these instructions to take with you and to use during your deliberations. I will first tell you about some general principles that apply in all criminal cases. Then I will instruct you on the rules that must control your deliberations. Finally, I will tell you about the specific law applicable to this case. General principles. The indictment is not evidence of guilt. The indictment is a document required to bring the case before you. Do not consider the fact that the defendant has been arrested, confined, or indicted or otherwise charged. Do not draw any inference of guilt from any of these circumstances. The defendant is presumed innocent of the charge. All persons are presumed to be innocent, and no person may be convicted of an offense unless the state proves each element of the offense beyond a reasonable doubt. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient for you to return a verdict of not guilty. You may find the defendant guilty only after a careful and impartial consideration of all the evidence, and only if the state has proved the defendant's guilt beyond a reasonable doubt. The state has the burden to prove every element of the offense beyond a reasonable doubt. If the state proves every element of the offense beyond a reasonable doubt, then you must find the defendant guilty. If it does not, then you must find the defendant not guilty. If, after you have considered all the evidence and these instructions, you have a reasonable doubt about whether the defendant is guilty, you must find the defendant not guilty. As the jurors, you review the evidence and determine the facts and what they prove. You judge the believability of the witnesses and what weight to give their testimony. In judging the facts and the believability of the witnesses, you must apply the law provided in these instructions. The evidence consists of the testimony and exhibits admitted in the trial. You must consider only evidence to reach your decision. You must not consider, discuss, or mention any other thing that is not evidence in the trial. You must not consider or mention any personal knowledge or information you may have about any fact or person connected with this case that is not evidence in the trial. Statements made by the lawyers are not evidence. The questions asked by the lawyers are not evidence. Nothing I have said or done in this case should be considered by you as my opinion about the facts of this case or influence you to vote one way or the other. You should give terms their common meanings unless you have been told in these instructions that the terms are given special meanings. In that case, of course, you should give those terms, the meanings provided in the instructions. While you should consider only the evidence, you are permitted to draw reasonable inferences from the testimony and exhibits if those inferences are justified in the light of common experience. In other words, you may make deductions and reach conclusions that reason and common sense lead you to draw from the evidence. You are to render a fair and impartial verdict based on the evidence admitted in the case under the law that is in these instructions. Do not allow your verdict to be determined by bias or prejudice. You may, if you wish, examine exhibits. If you wish to examine an exhibit, the foreperson will inform the court and specifically identify the exhibit you wish to examine. Only exhibits that were admitted into evidence may be given to you for examination. Certain testimony will be read back to you by the court reporter if you request. To request that testimony be read back to you, you must follow these rules. The foreperson must make the request in writing and sign it. That request must, 1, state that it is requesting that testimony be read back. 2, state that you have a disagreement about a specific statement or of a witness or a particular point in dispute. And 3, identify the name of the witness who made the statement. The court will then have the court reporter read back only that part of the statement that is in dispute. The law requires that you render a verdict of either guilty or not guilty. The verdict of not guilty simply means that the state has not proved the defendant guilty beyond a reasonable doubt. You may return a verdict only if all 12 of you agree on this verdict. When you reach a verdict, the foreperson should notify the court. Evidence of wrongful acts possibly committed by the defendant. During the trial, you heard evidence that the defendant may have committed wrongful acts not charged in the indictment. You are not to consider that evidence at all unless you find beyond a reasonable doubt that the defendant did in fact commit the wrongful act. Those who believe the defendant did the wrongful act may consider it. Even if you do find that the defendant committed a wrongful act, you may consider this evidence only for the limited purpose I have described. You may not consider this evidence to prove that the defendant is a bad person and for this reason was likely to commit the charged offense. In other words, you should consider this evidence only for the specific limited purpose I have described. To consider this evidence for any other purpose would be improper. Evidence of prior convictions of defendant. Evidence that the defendant was previously convicted of an offense can be considered only for the limited purpose of determining if you believe the defendant. Even though evidence was introduced that the defendant was previously convicted of an offense or offenses, you must not consider it as evidence of guilt in this case. You may choose to disregard the evidence and not consider it at all. But if you choose to consider the evidence, you must consider it only for the limited purpose of determining if you believe the defendant and the weight to give his testimony. Rules that control deliberations. You must follow these rules while you're deliberating and until you reach a verdict. After the closing arguments by the attorneys, you will go into the jury room. Your first task will be to select your foreperson. The foreperson should conduct the deliberations in an orderly way. Each juror has one vote, including the foreperson. The foreperson must supervise the voting, vote with other jurors on the verdict, and sign the verdict sheet. While deliberating and until excused by the trial court, all jurors must follow these rules. 1, you must not discuss this case with any court officer or the attorneys or anyone not on the jury. 2, you must not discuss this case unless all of you are present in the jury room. If anyone leaves the room, then you must stop your discussions about the case until all of you are present again. 3, you must communicate with the judge only in writing, signed by the foreperson and given to the judge through the officer assigned to you. 4, you must not conduct any independent investigations, research, or experiments. 5, you must tell the judge if anyone attempts to contact you about the case before you reach your verdict. Your sole duty at this point is to determine whether the state has proved the defendant guilty. You must restrict your deliberations to this matter. After you have arrived at your verdict, you are to use the form attached to these instructions. The foreperson should sign the line that corresponds to your verdict. After the closing arguments by attorneys, you will begin your deliberations to decide your verdict. Law specific to this case. The state accuses the defendant of having committed the offense of possession of a firearm while having been previously convicted of a felony offense. Relevant statute. A person commits the offense of possession of a firearm while having been previously convicted of a felony offense if he intentionally, knowingly, or recklessly possesses a firearm and at the time of the offense, the person had been convicted of a felony offense, and the person possessed the firearm before the 5th anniversary of the date of the person's release from confinement following conviction of the felony offense. Definitions. A firearm means any device designed, made, or adapted to expel a projectile through a barrel by using the energy generated by an explosion or burning substance, or any device readily convertible to that use.
That's pretty specific.
Means actual care, custody, control, or management. A person intentionally possesses a firearm if the person has the conscious objective or desire to possess the firearm. A person knowingly possesses a firearm if the person is aware that he is possessing a firearm. A person recklessly possesses a firearm if the person is aware of the substantial and unjustifiable risk that he is possessing a firearm, but consciously disregards that risk, and the risk is of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all of the circumstances as viewed from the person's standpoint. Application of law to the facts. You must determine whether the state has proved beyond a reasonable doubt 5 elements. The elements are that 1, the defendant in Jefferson County, Texas, on or about September 14th, 2024, possessed a firearm. 2, the defendant did this intentionally, knowingly, or recklessly. 3, at the time of the possession of the firearm, the defendant had been convicted of the felony offense of evading arrest or detention with previous convictions on April 13th, 2022, in cause number 20-34416 in the Criminal District Court in Jefferson County, Texas. 4, at the time of the possession of the firearm, the defendant knew that or was reckless about whether he had been convicted of a felony offense. And 5, the defendant possessed the firearm before the 5th anniversary of the defendant's release from confinement following the conviction of the felony offense. You must all agree on the elements 1 through 5 listed above. If you all agree that the state has failed to prove beyond a reasonable doubt any one of elements 1 through 5 listed above, you must find the defendant not guilty. If you all agree that the state has proved beyond a reasonable doubt all 5 of the elements listed above, you must find the defendant guilty. And then that has my signature, and then the last page is the verdict form. The top is titled Verdict Not Guilty. We, the jury, find the defendant, Romeo R. Johnson, aka Romeo Randolph Johnson, not guilty. And then there's a space for the signature and the printed name of the foreperson. And then below that is titled Verdict Guilty. We, the jury, find the defendant, Romeo R. Johnson, aka Romeo Randolph Johnson, guilty of unlawful possession of a firearm by felon as charged in the indictment. And again, there's a line for the signature and the printed name of the foreperson. Mr. Coleman, the state has the right to open and close closing arguments.
At this time, the state waives its right to open, but reserves its right to close.
All right, thank you, Mr. Coleman. Mr. Wilkerson, you may proceed.
They waive their opening. They're going defense goes first, then the state gets the last bite.
Please, court.
Yes, sir.
Ladies and gentlemen of the jury, I want to thank you again for sitting through all of this. I told you at the beginning that I didn't believe this case was as straightforward as state's attorney told you. I outlined, and the state's attorney as well outlined some of the evidence that you would see in this case. And so let's talk about that for a minute. So you have a video and some photographs that are unclear and you can't see what's actually being held. You have testimony from a defendant given in a murder trial where both there and here, he has been 100% real with the jury. He's told y'all about the things that he's done wrong in his life. He's told y'all about the street life. He's told y'all about what the behaviors he used to be engaged in. He's been real with it. Meanwhile, the state wants to put on a person by the name of Derek Cooper to essentially say, oh no, he robbed me with a firearm. And then Mr. Cooper says that the defendant knew he always had money, right? Because he worked, etc. Well, that's an awful lot of theft for someone who always has money. And I can't imagine not knowing people came to my house. I just really can't. That is not a world experience that I can relate to. And I don't believe it is relatable unless people are coming when you're out of your mind. I just don't. And I don't think you should either. So let's look at the sequence of events and what happened. The defendant took the stand, as you heard, against the advice of counsel in a prior trial, where he was on trial for one of the most serious offenses you can be charged with, right? Indicted for, convicted of even. He was fighting for his liberty, his entire future. So he took the stand and he told the truth. He told the truth then, he's told you the truth now. Now, the state wants you to believe that since the defendant never said, well, the gun wasn't a BB gun, it wasn't a replica, it wasn't an airsoft gun, that the defendant essentially is letting the state believe that it's a firearm. But what they don't want you to think about is that both the detective, as the detective told you, and the state at that hearing both had the opportunity to clarify whether or not that gun was indeed a firearm. We can't tell. We can't see it. I mean, I see something gray in Ethan Smith's hand. And what about Ethan Smith? Why wasn't he here to tell you exactly what it was that he gave the defendant, if it was indeed a firearm? Why not? You, in your charge, the term firearm is defined specifically for you, right?
This is key,
and as much as the detective, or I'm sorry, Officer Carmouche would want you to believe that the colloquialism gun always applies to a firearm, that we simply know is not always the case, right? And we know that toys, we know that airsoft guns, for instance, are looking more and more real. You know, that's why the law doesn't even require you actually have a firearm for an aggravated robbery or an aggravated assault. All you have to do is make somebody believe you do. Maybe you could do that with a toy.
We shouldn't get into that argument.
You could do that with your hand. And despite the state's prior opportunities, they didn't do it. Ladies and gentlemen, it is not the defense's job to disprove the state's case. It is the state's job to prove their case to you beyond a reasonable doubt. You know, in voir dire, we talked specifically about the example of a firearm in terms of the puzzle pieces. Y'all remember I asked y'all about it, and I asked you about that piece that if at the end of it, you put it in the puzzle and that little tip is orange, it changes the picture entirely. Well, ladies and gentlemen, you certainly have more of the story or more of the context than I expected you to have, but you still don't have all the pieces. And you don't have all the pieces because the state has not given them to you. The defendant doesn't have to call a witness to say, oh no, that wasn't a firearm. The state, knowing who the person in the video was, the state, the officer, detective at the time investigating the underlying case, talking to Ethan Smith. But he's not here to tell you that, yeah, he gave this defendant a firearm on that night. And ladies and gentlemen, the only way that you can prevent the state from serially indicting cases is to find this defendant not guilty. You know, when we often say in terms of law school that the guilty stand in place of the innocent, right? Because if the government can execute an invalid search warrant on a guilty person, they can do it on an innocent person as well. And for those reasons, certain policies, procedures, rules, and laws must be followed. In this case, you have the opportunity to take a stand against, okay, well, I didn't get him on that one, so now I'm going to immediately re-indict him on something else. A long time after the original investigation took place. There's only one way to prevent. Just like there's only one way to prevent an officer from filing a false affidavit, right, to get a search warrant, or to execute a search and seizure without a warrant, which is to exclude the evidence, right? That's what happens if those procedures are not followed properly, if evidence is seized without it being, without a warrant or some sort of probable cause with an exception set forth. That's the mechanism by which we hold our government to account. And those are the procedures and the mechanisms by which you need to hold the government to account here today. In terms of proof beyond a reasonable doubt, no, it's not beyond all doubt, right? And like we talked about before, dear, we don't go around talking about, I believe by preponderance of the evidence that this happened, or I believe beyond a reasonable doubt that. But what we were able to discuss is that beyond a reasonable doubt is the highest burden of proof. And so if it were your loved one sitting in that seat, remember we talked about the burden of proof required in order to terminate the relationship between a parent and a child? And how that burden of proof is lower than the state's burden of proof here? The state wants you to make a lot of assumptions about evidence that they had the opportunity to present to you, but did not. And you have to ask yourself why. If it's sufficient to come in here and just presume that someone's guilty based on the way one situation played out, or based on things that were said that weren't clarified despite the opportunity, if it's okay to come in and say, well, we didn't get you on that, so we're going to refile and try and get you on something, okay, then it's okay for everybody. And that is the dilemma that you're faced with, right? Either presume that the phrase gun, which is not defined in law, is interchangeable with the phrase firearm, which is defined by law and defined in your charge. There are reasons that those definitions exist. Ultimately, at the end of the day, whatever your decision is, that will be justice. And I believe that, and I believe that wholeheartedly, and I'll tell you what. I believe that all 12 of you will go back there and talk about the evidence and talk about presumptions that perhaps should be made and presumptions that should not be made. Talk about what proof really is. Right? Officer Carmouche believes it was a firearm. They want you to believe that because there was a murder later on that they alleged the defendant was near, or at one time alleged the defendant committed, but was acquitted of that offense, that means he must have had a firearm. He was acquitted. There are reasons.
He's doing a better
But what it
closing
means is
than his whole
the
trial.
state didn't prove their case there beyond a reasonable doubt. And you've got just a glimpse of some of the evidence that was presented in that case. Finally, I want to talk to y'all just very briefly about what I call, or what I say, call it my don't go along to get along speech. When y'all are deliberating, unless a piece of evidence changes your mind, unless the discussion and there's argument about a piece of evidence that convinces you beyond a reasonable doubt, if you're not guilty, don't change to guilty just to get to go home, because I promise you it will happen. At some point, it will happen. You won't be stuck here for 6 weeks. I promise you. Now, ladies and gentlemen, today is the day. Right? We all come in here with our life experiences. But 5 years from now, 10 years from now, you don't get to be standing at your sink and think, you know, that case that I was a juror on, I wonder. Or someone you love be accused of something similar and think, wow, I saw this similar situation and I chose to convict that person. If you have a doubt, today is the day to express it, because you do not get to revisit it later. Give the defendant justice, find him not guilty as the law requires. Thank you.
Thank you, Mr. Wilkerson. Mr. Coleman?
He did a better job
Thank you,
closing than
Armin.
the entire trial.
Counsel, ladies and gentlemen of the jury, I want to begin by thanking you on behalf of the District Attorney's Office, and thank you on behalf of our community for your time and attention. This has been a brief trial, relatively brief trial, but from time to time I've looked over, and I think that you all have been engaged. I think that you all have paid very close attention to the evidence and the testimony in this case, and for that, I thank you. I began my opening statement by saying that this is both a straightforward case and a serious case. Straightforward in the sense that either you believe what you saw in the video, and either you believe that the defendant's sworn testimony that he, quote unquote, gave the gun back to his compadre there, or you don't. It's just that simple. I'm not going to try to gloss it over. I'm not going to try to make a big production about anything. It is straightforward in that sense. Either you believe the video and you believe the defendant's own words, or you don't. It is both straightforward and serious. Serious in the sense, now that, to borrow a phrase from defense counsel, that you've seen the whole story, heard the whole story, it is serious in that sense. No doubt, no wonder why we have a situation in Jefferson County with gun violence that we do. Because this is the kind of case where it starts, okay? Arguments in the parking lot, 2 a.m. in the morning, and the next thing you know, we have an escalation. How many times have you heard a story about gun violence and you wonder, why don't they do something about it? Again, I'm borrowing a phrase from defense counsel. He said during his closing, today is the day. I'm going to say the same thing. Today is the day. Today is the day that you are they. Today is the day that you get to say, you know what, at least in this case, based on the evidence, we're going to stop this before it escalates. We're going to find this defendant guilty based on the evidence in this case before it escalates. You know, defense counsel, and I don't mean to be flippant about it, but I'm going to borrow another phrase from him. He says, the state wants you to make a lot of assumptions. No, what I don't want you to do is make assumptions. I want you to follow the jury charge that the judge gave you, and you'll get a copy of it to take to the back with you, and you can read it for yourself. In this very charge, don't take my word for it, read it yourself. It says you are permitted to draw reasonable inferences from the testimony and the evidence in this case. That's what this says. That's the law that the judge is giving you. The law says you can draw reasonable inferences. In other words, I want you to draw reasonable inferences from that video, reasonable inferences from the testimony of Officer Carmouche, reasonable inferences from the words of the defendant himself. You can infer that he possessed a gun, a firearm. You can infer that based on the testimony. You can do so by using your common sense. You do not leave your common sense at the door when you come in here to serve as a juror. And I'm asking you to draw reasonable inferences based on your common sense. Do you think this defendant was out there at 2 a.m. in that parking lot with a BB gun? I suppose it's possible. But if you look at how worked up he is on that with that towel and going after that guy, I don't know. Even if that gives you some pause, again, from this very witness stand, he said under oath, I gave that gun back. I gave the gun back. I gave the gun back. This defendant gave you the confirmation that you need to find him guilty, to find him guilty of this offense. A couple of other things I want to point out is that this jury charge tells you that you are the sole judges of the credibility of the witnesses in this case. In other words, you can believe some, none, or all of what you have heard. And when it comes to this defendant, I don't know. I'm reminding of the phrase, pick a horse, just pick a horse and ride it. I mean, at first we start out, well, there wasn't a gun. I didn't know it was a gun. I didn't get a chance to explain at the previous court proceeding. And then it went to, well, it was wrapped in a towel. I didn't know what it was. And lastly, wait a minute. I was being investigated for a murder. So I don't know. It's kind of unfair for me now because I had the gun. But I didn't know if I knew I was being invested for the gun, I would have done something or said something different, that kind of thing. You can, again, disregard some, none, or all of a witness's testimony. And I submit to you that with regard to that whole business, you can use your common sense on giving the defendant the credibility or the weight to his testimony that you would. He told the truth. This is another thing the defense counsel said. He told the truth then. He told the truth now. I would take issue with that. I mean, here's what I remember from that first court proceeding is that the defendant said he had never been charged with a robbery. But today you heard from that stand that he admitted to at least one robbery. Doesn't sound very truthful to me. I mean, I would submit to you, use your common sense. If you were accused, arrested, either charged or pled to and served some time on a robbery, that ain't something you usually just kind of forget about. And that's not something you get on the stand. I'll submit to you under oath and say, I've never been charged with. Again, another reason to believe either some, none, or either some, none, or all, some, or none of his testimony, if that's what you choose to do. There's another definition of the charge about possession. It says it's either actual care of, custody, control, but what it doesn't say is for how long. There's no time limit. Believe you me, if there was a time limit on that in the law, the judge would have put it in the charge. If it says you got to possess it for 5 minutes, 15 minutes, for 5 hours, believe me, she should have put it in. She would have put it in there. So just keep that in mind. Possession, no matter how brief, if it was just for a little while, he possessed that firearm. Another thing about the law. You don't need the actual gun, okay? If you needed the actual firearm and you couldn't infer that it was a firearm, believe you me, it would be in this charge. The law, the judge would give you that law if it was a legal requirement, if you had to have the actual gun. What I submit to you is not unlike what we talked about during jury selection about that jigsaw puzzle, if you got enough of the pieces here, to again infer using your common sense that he possessed a firearm, I submit to you that that's enough pieces of the puzzle for you to make your decision. If you know it, if you feel it, again, going back to jury selection, in your head, your heart, and your gut, based on your common sense, based on the inferences, reasonable inferences you can draw from testimony, then I'm asking you to find this defendant guilty. If you feel it in your head, your heart, and your gut, based on reasonable inferences from the evidence and the testimony states, I'm asking you to find this defendant guilty, not because I say so, not because Detective or Officer Carmouche says so, but because it's what the evidence demands. This is the last phrase I'll borrow from defense counsel. He said that would be justice. Yes, it would be justice to find this defendant, Romeo Johnson, guilty of unlawful possession of a firearm. Because that's what he did, and that's what the evidence demands. I'm asking you to follow your oath. I'm asking you to find him guilty. Thank you.
Thank you, Mr. Coleman. All right, ladies and gentlemen, this time you've heard all the evidence, the court's charge and closing argument. I'm going to hand the charge to the bailiff. She will take you to the jury deliberation room where you will begin your deliberations, and court will be in recess until you reach a verdict. Ma'am, if you'll just stay there, we'll give you your instructions in just a minute. For the rest of you can go back with the bailiff.
All right, they're headed back as soon as they leave the room. How many are going in? 1, 2, 3, 4, 5, 6, 7. We presume more. We're starting the timer. Our court watcher is going to give us a heads up when we hear that there is a verdict in the court. But until then, we have our timer running. Let's get that up here. I just cannot. My old eyes. I'm going to need a big TV. That's what I need. I need a massive TV so I can see everything across the room. I just can't with this one. All right. About a minute into deliberation so far. So she said 12, and then, ma'am, you get to stay here. So 12 people go in and deliberate. 2 hours at the most. Not going to do a poll on the time on this one. But do you guys remember what the verdict was? Let's do another verdict poll. Let's do that one. Because we did the poll and then there was rebuttal. So I owe you another one. This is going to be simple. Is the defendant guilty? As always, the first answer is going to be no, because there's a presumption of innocence. Okay, and I've got the charges in there. There's no excuse. There's no excuse if you vote the wrong one. Read the poll first, people. Read it first. Without seeing the video, I can't vote. Let me ask you this question, Anna. Would seeing the video tell you whether it was a firearm or a BB gun? Like, do you feel that watching the video, ranked about a 7 as far as clarity goes out of 10, would it tell you if it was a firearm, which is illegal, or an airsoft gun, which is not illegal? Unless you can see the orange tip, that's a good call. Yeah, orange tip, that's a dead giveaway. I'm guessing it wasn't there. I'm guessing there was no orange tip visible. The defendant said gum, right? See, I want to go see what Judge Middleton's doing. He's in the new courtroom, and he said there was the witness he called today to the stand said the first person to testify in this room in 25 years. Let's go over there real quick and see what he's up to here. Hoping it's not.
Do you have any copies of the written notices that you've given Mr.
No, I don't.
Oh, it's still the cat case.
Everything is in file.
How many written notices have you given them?
I lost count.
You lost count, that many.
Yeah, there was too many of them.
What do you put these written notices on?
All the stuff he has around his trailer.
No, I'm sorry, let me clarify.
The
Are these typed out letters that you give him?
Written, no, they're written.
Huge echo.
Yeah.
And you mail them to him?
No, I put them right on his door. I put them in a little plastic bag and put them right there.
You put them in a plastic bag and you
Yeah, and put them right in his door.
But you keep a copy of them before you do that?
Yes, we do.
Okay. But you don't have any of those with you here?
No.
And did you give any to your attorney?
I don't know.
And you say that this lamp is a fire hazard.
Yes, it is.
Are you a firefighter?
No. I know when it's
an electrician?
Nope.
Are you a code enforcement officer?
Nope.
Have you ever contacted a code enforcement officer about this issue?
No.
Are you a firefighter?
Are all outdoor lights or outdoor cords a fire hazard?
What do you mean?
So he's got a cord
Outdoor
here.
lights.
It's a fire hazard because there's a cord here and it's outside, is that right?
Yeah.
And everybody who has...
There's nobody else has a light like he does.
Do you have lights on your property?
What?
Do you have lights on your property?
Light bulbs, yeah.
Christmas lights?
Yep.
Yep.
Outside?
Outside.
Plugged in?
Not right now.
But
Only
they
for
have
Christmas.
But they have been plugged in.
Yes, I do. I plug them in for Christmas.
Mine are unplugged, just for the record. My lights
Do
are
you
down.
have you ever had cinder blocks in your yard?
Nope.
Never. Have you ever had wood in your yard?
Wood?
Mm-hmm.
Yeah.
Like 2x4s?
Yeah, I got 2x4s. I picked in my room right now.
They're in your lot?
Yes. No, they're under the trailer.
So they're under your trailer?
Yeah.
You don't have anything, you don't have anything in your lot
Old cars?
that isn't...
Broken lawnmower?
I got two little storage. I put everything in there. When me and my wife go to plant flowers, we take all our stuff out and start planting flowers. And he knows it because he always goes through there.
So your shed, you have a
Yeah.
shed?
Yeah. I got a shed.
Did you install that shed?
No, I bought it.
Bought it, okay. And you moved it to your lot?
Yes, I did.
Okay. Would you recognize?
Everybody else has a shed.
Everybody else has a shed?
Yeah.
Okay. If I showed you pictures of your lot, would you
Yeah.
recognize it?
Show them.
I am emailing the court what I have marked as defendant's proposed Exhibit A. I'm going to put them all over. No. Unless, I was anticipating HDMI, but I think this, so that I could zoom in, but I think this will work okay.
It hasn't reached my email yet. That's 12 feet from there to here, so that takes a while for it to get it.
I sent it to 3B Civil.
Oh,
and I should have sent it
directly to me.
Yeah, that's my fault, Judge.
It has to go to space first. Have to send it up to the sky before we can download it. Bring it back to the same location on Earth.
It should be. I guess, Judge, this is what I get for trying to be in the technological age and not to.
I'm not saying you didn't send it, but it hasn't arrived here yet.
Extra copy.
My email to you.
I can't access it.
Yeah, we might have to do that. So we don't have any electrical outlets up here, do we?
No, we don't.
This court was pre-electricity.
It wasn't designed with that in mind.
You mean they didn't have electricity when they built this?
We do. They did not have electricity in 1899 when this building was open. Here it is.
Can you plug it into the mic?
All right, I have them. I can screen share them.
I would do the screen share, except now I'm also low on power.
I'll try to screen share from here.
Could go borrow. No, don't do it. Okay.
Can we see it, Judge? Let us see. Let us see.
All right. There is the third of the 3 pictures that you sent to me on this.
Is that your house, Mr. Trevino?
Yes, it is.
Is that a fair representation of what it looks like right now?
That's my house.
Do you have any reason to believe this is not what your house looks like right now?
I don't see any cats.
What do you mean, does it look like it? That's my house.
Okay.
That better be
I
my
move
house.
for the admission of proposed exhibit B.
I think we have a foundational issue as far as who took it, when it was taken.
I'm not gonna get hung up on that. He said it's his house. That's what it looks like today. There's no smoking gun in the picture. But, do you want to put in all 3 of these?
Yeah.
Can we see the other ones, Judge?
What do you?
I'm sorry, sir?
What do y'all?
Yeah, I'm not sure how relevant it is. There's an appropriate objection for that. But
Well, I figured I'd wait till Ms. Bauer got through with, at least further along with her questioning. I gave her a little latitude.
We have a little windmill thing.
Yeah,
Windmill
that's my
sunflower.
house.
Bird
I got
feeders.
picket fence. I got white picket fence, but,
Looks
and a
nice.
porch.
No reason to believe that's not your house right now.
Why are you telling me it's not?
No,
It's
it
mine.
is, it is, right? That's what your house looks like?
Yeah,
I move for the admission of defendant's proposed exhibit A.
Same foundational objection, Your Honor, and we'll wait for the relevance objection until we get through the next picture, if we get through it.
The next picture, does it have like, what, 1 million cats in it or cinder block? What? Here we go.
And there is a third picture, which appears to show a shed.
A tree stump and trunk, some buckets or planters, a shed.
Same question, Mr. Trevino, is this your house and your shed?
yep,
Any reason to believe it's not your house and your shed?
that's my house.
Okay.
Who's going around taking pictures of his house? And why?
Well, yeah, that'll be okay. Looking at this picture, Mr. Trevino. You have lights along here?
Yes, I do.
Can you plug those
All the
lights
way around, yes.
Okay.
Yep.
Hold,
I
please.
plug those in Christmas. Yep.
Hold,
Is that all
please.
on one string of lights, or does it take a couple to get all the way around?
No.
We need to hold for a second. What's going on? People are coming back in. Do we have verdict music? Let's see. Let me check. I've missed.
Okay, let the record reflect state's attorneys present, defendant, and defense counsel are present, and received a message that the jury has reached a verdict. If you'll please bring the jury in.
We have a verdict. 16 minutes of deliberation. 16. An ice cube couldn't have melted in the time the jury took to deliberate this trial. The defendant is charged with not murder. That was before. Acquitted of that one. He's charged with carrying a firearm by a convicted felon. The evidence in this case is a video that shows him carrying something that looks a lot like a firearm, and of course his testimony saying that he carried a gun. The question is, was the gun a firearm? The testimony's been back and forth. Defense has struggled to do anything other than drink Mountain Dew in this case, but they did manage to put together a rather decent closing argument, calling on the jury's sense of freedom and justice.
Let the record reflect that the jury seated, state's attorneys present, defendant, and defense counsel are present. At this time, I would ask the foreperson, has the jury reached a verdict?
Your Honor, we have.
And is it the unanimous decision of all of the members of the jury?
Yes, Your Honor, it is.
Thank you, sir. You can hand it to the bailiff, please.
Bailiff's going to hand the verdict to the judge.
Johnson, if you'll please rise.
Here we go.
We, the jury, find the defendant, Romeo R. Johnson, aka Romeo Randolph Johnson, guilty of unlawful possession of a firearm by a felon as charged in the indictment. It's got the signature and the printed name of the foreperson. You may be seated. Does either party wish to have the jury polled?
The state did not. Yes, Your Honor.
So what that means, ladies and gentlemen, is I'm just going to go through and ask each one of you individually if this was your decision and your vote. And so I'm going to start on the top and go across and then come back around. So I'll start with the top. Ma'am, was this your individual verdict?
Yes.
Sir, was it yours?
Yes.
Ma'am, was it yours?
Yes.
Sir?
Yes.
Sir, was it yours? And sir?
Yes.
Ma'am, was it yours? And then we'll come down here. Sir, was this your individual verdict?
Yes.
Sir, was it yours?
Yes.
Sir, was it yours?
Yes.
And ma'am, was it yours?
Yes.
And sir, was it yours? All right, thank you very much. And what that means at this time is I will accept your verdict, and at this time find Mr. Johnson guilty of the offense of unlawful possession of a firearm by a felon. That means that the first phase of the trial is complete, and we'll move into the second phase, which is the punishment phase of the trial. And Mr. Coleman and Mr. Wilkerson, are y'all ready to proceed? Do you need just a short break?
State's ready to proceed. Defense is ready, Your Honor.
All right, and so Mr. Coleman, if you will read the remainder of the indictment.
Apparently he's not ready.
Do you have it handy? Okay. It's the enhancement paragraph. He'll need to plead true or not true to that.
Apparently the one thing we could not see, which was the jury, the video was rather clear to the jury. Possibly the description.
And the grand jurors aforesaid, upon their oaths aforesaid, do further present in and to said court at said term that before the commission of the primary offense, the defendant was finally convicted of the felony of robbery second degree on March 9, 2015 in clause number 14-21127 in the criminal district court of Jefferson County, Texas, against the peace and dignity of the state.
And is that allegation true or not true?
True.
Okay, have a seat. All right.
That was prior conviction.
Mr. Coleman, you ready to call your first witness? Or do you wish to make an opening statement?
State wages don't say.
All right, you may call your first witness.
This time before calling my Ayden, I'd like to offer a certified criminal history. 12 or 15?
I showed 12.
12 cycles?
Approach existing.
Yes, sir.
I have to mind upstairs. Oh, thank you.
Selena, that's awesome. You've worked out something to get access to the seats. Media does not get any extra seats. There are only 5 media members going. The rest are all designated by family members. So that's awesome, Selena. It's always good to be kind. Yes, it is.
This time, the state offers what's been marked as state's exhibits number 12, 13, and 14. I'll proffer to the court that 12 is a certified criminal history record from DPS. 13 is an individual judgment for a 2008 offense of unauthorized use of a motor vehicle. And 14 is a summary thereof of all of this. And for the record, I'm tenured to defense counsel for his inspection.
It's a long inspection.
Your same objection as previously with regard to states 12, 13, and 14.
Say it again. I don't know which one what objection you're talking about.
Relevance based on establishing that these are records related to the defendant.
They're certified. It's the certified criminal history, the redacted version that I offered earlier. I'm happy to provide it to the court. This is just a complete version of it. Same identifier.
So based on, well, let me look at this. So based on those identifiers that were, that I previously found in the shortened version of, which would be State's Exhibit number 12, the Department of Public Safety, which includes date of birth. It includes the picture, the thumbnail picture, that matches the date of birth. So with regard to that judgment that I previously looked at, I don't remember what that was. Let's see. Which one? 11. So 10, which was the evading arrest conviction judgment. And then State's 13. So, okay, so with regard to State's 12, the objection is overruled. State's 12 is admitted. It is just the complete copy of what I admitted part of earlier in the trial. What is the specific objection with regard to State's 13, which is the, it's a judgment?
Same objection, Your Honor.
Y'all come up for a second.
Well, the judge is figuring that out. I have a piece of random trivia for you. Have any heard of the Peabody Hotel in Memphis, Tennessee?
What would the argument be on this one with regard to identifying factors other than in mind?
You got it.
The Peabody Hotel has
Okay, that's what I need.
has ducks.
And that should be on this as
They
well.
have ducks, 5 ducks that swim in the hotel fountain inside. And twice a day, these ducks are paraded through the hotel, once at 11 o'clock in the morning and once at 5 o'clock at night. But they come down a special elevator. There's a duck master that directs them. They walk on a red carpet from their rooftop. They have a rooftop duck house, very expensive one. They come down a special elevator.
Okay, with regard to State's 13,
Get to swim in the
it
pond.
also has the state ID number, which is TX 071111416, which matches the DPS certified criminal record history. On the front page of that, it shows Texas DPS 071111416. Again, in that document, which is Exhibit 12, it has the picture identifying Mr. Johnson that I can myself look at and identify Mr. Johnson here in court. He's also been identified by other parties in the trial. So for that reason, State's 13 is admitted. That is overruled. Now, with regard to
approach briefly,
okay.
While they approach, I'll finish the rest of the story. This started in 1933 when the owner of the hotel came back drunk from a hunting trip and dumped his live decoy ducks in the pool, in the fountain, and the guests loved it. And
see the date of birth, and I compare the date of birth with date of birth there.
Yeah, I don't think anything about that is commenting.
So now I need to go see these ducks.
Or he can argue with the jury.
The jury is going to choose the sentence here.
I mean, if anything, it might go to the white
At least make a recommendation.
You can show it, and if they don't believe it, they don't have to believe it. That's their. But I'm going to allow State's 13 based on my represent on the evidence that's being put forward for me with regard to identification, which is what's necessary. And then with regard to 14,
I'm offering that as a summary, Judge. Rather than going through each individual instance or event, I want to offer that to summarize those exhibits.
and what is the objection to states 14?
Your Honor, based on the prior rulings, the court withdraw the objection.
Okay, it's admitted then. Right. And if you'll remove those stickies, please.
Yes, ma'am.
The defense lawyer is sponsored by
Also,
Mountain Dew.
I'm sorry.
Let me take this off before I forget. I have another exhibit.
Okay.
But I want to do this because I don't want to leave.
Thank you.
I have also marked as state's exhibit number 15, and it may be a little duplicative, but we have our reason for doing it. It's also, while it's contained in the certified criminal history record, it's also a standalone judgment for the robbery that is mentioned as an enhancement in the indictment as well. I want to offer the actual judgment for that, and I've marked it as state's 15, and for the record, I'm tendering the defense counsel. It's a certified copy.
This, I think, might be the fastest verdict ever. Yep. We're reading. Be great if you shared with us what you're finding.
Hello.
Judge, with regard to the exhibit, same objection as previously for preservation purposes. However, in addition, we object to the what appears to be the docket or a docket attached to the judgment.
I would agree that it should, if I'm going to allow it, unless there's some identifying factors that would be necessary on any other pages, that just the judgment document itself, not the docket sheet and anything like that.
There is a thumbprint on the docket sheet, but however, we don't.
Well, I don't look at that unless you're going to have an investigator come. So, what was the answer?
Oh, no, we're not opposed to removing the docket sheet, Your Honor.
And then, of course, there's, well,
or any of this other.
So why don't you remove everything that's at least under that objection, that's objectionable? And then I'll take a look at it with regard to.
Take out the objectionable stuff. There's no more spice, Your Honor. We need the spice.
Okay. Remark it sits up at the later on.
Should we go back to the other court while they're sorting this out?
Stay off of state 15 with the pages taken out by certain pages removed by defense counsel.
So the objection then is with regard to identity?
Yeah, sure.
So I've got an indictment and a judgment.
Yes, it comprises the new exhibit judgment.
So with regard to the indictment being included in it, you don't have an objection to that if I allow it in?
If you allow it in, I don't have an objection
to that part of it. Can I see the,
Sure, Dr. Minister.
yeah, either 12 or 10. So with regard to state's exhibit number 15, the state identification number is the same at 07111-416.
I don't like podium.
Style the same, Romeo Randolph Johnson. The date of birth. It's not the same on this indictment. It's off by 1 day. But the judgment itself, I guess, y'all come up here for a second.
This court record should not be this difficult to understand. For a judge, even. That poor tie. That tie has been hung on a doorknob with that very knot in it. A lot of times. He might have spilled something on his shirt. Just looking. This is a question from the judge about the judicial record she's trying to take note of.
Remember in the beginning when we started 110 years ago?
It was a short trial, but it does seem like 110 years. He's looking at her soul when he glances at the camera. Thank you, Red. We need to have one final thumbnail. I'll update the video with that. Bad lip reading, anybody? I've always wanted to know what was said in sidebars, but I've never wanted to be this close to the sidebar. I feel like I'm right there. Like he's jabbing me with a pen type. I'm that close. I got 2 large fries and a milkshake.
I'm going to sustain my own objection.
This guy's keyed up. Too much Mountain Dew, dude. Too much Mountain Dew. I'm getting whiplash from looking at his eyes. They're all over the place.
Minute break. We'll try to get started at 3:20. Keep in mind all the instructions that you were previously given. You're excused for about 10 minutes. Before y'all go, also, is there any objection to releasing the alternate now that we've gotten through the first phase?
No.
So now that we've gotten to this point, ma'am, we can excuse you. You're welcome to sit in the courtroom and listen if you'd like. You're also welcome to go. We appreciate you very much. All right, y'all can go take a break as well.
We're going to jump to another court. Back to Judge Simpson, or Judge Middleton.
I have 2 and 3.
2 and 3 are coming.
Okay.
2 and 3 are going to be releasing.
All right.
Didn't expect it yet.
Say, I don't like the acoustics in this
That's
court.
it.
Is that one of the pictures that you took?
Yes, sir.
All right. And also on April 6th?
Mm-hmm.
Also with your cell phone?
Yes.
Any objections, Power?
One moment, Your Honor, if I may. This is the first I've gotten any of the exhibits from the plaintiff, so, as well. So we're
There's no discovery?
trying to figure out what we're combating.
What is this a picture of?
It's a tarp that he put so he could cover up all the stuff he has in his yard.
So these are the debris and bulk items you're
Yes, sir.
referring to?
And Your Honor,
Just a minute.
I think any objections I would raise would go to the weight and not the admissibility. So,
All right, Exhibit 4 is admitted.
I'm sorry, Judge, is it 2?
no.
No,
it's
2 and
gonna be
3 are
released.
other documents.
Second, they have to introduce if they got snow blower and lawnmower.
All right, so he's got a big pile of stuff
Mm-hmm.
outside his trailer that he covered up with a tarp.
Yeah, that's covered up with tarp.
Is that allowed?
No,
What's under the tarp?
Nobody knows.
I don't know. I can't remember what all he had. He had a lot of stuff.
All right, so can tenants at the park pile stuff out on their lot and then cover it up with a tarp?
Yes.
And they can do that?
And they're not supposed to.
Okay. All right, that refers then to that component of the notice to quit.
I'm going to sustain my own objection.
All right, any further questions for Mr. Trevino?
Not from the plaintiff, Your Honor.
All right,
have
you
to find
may
another
be
court.
recalled, but at this point, you're free to step down.
The judge, your questions did prompt me with a follow-up question.
All right, she has more questions.
Judge asked you about the notice to quit that was dated December 19th. You testified that you live in the park at lot 67. 67 Thomas Court. If I were to mail you a letter,
I ain't gonna get it.
you're not going to get it.
No,
If I were to mail it to just for the purposes of the record, let me finish the question. If I were to address a letter to
We don't need the address.
would you receive that letter?
Not there because we don't receive no mail in the trailer park. Everybody is issue a mailbox in Centerville.
Everybody at the park.
Yeah?
That's that's universal.
Yeah. Everybody's got a post box in Centerville. Mine is P.O. Box 282.
Okay.
So, yeah.
Thank you, Judge. Thank you, sir. No further questions at this time.
All right, and for what it's worth, this part of the file, demand for possession says it was mailed by first-class mail by an agent of Jarrett Levine to Craig Kloppenstein and Gretchen Anderson at 59 Thomas Court.
Don't need the address.
As manager of the park, then, Mr. Trevino, would mail addressed to 59 Thomas Court be deliverable?
59?
Thomas Court. If it was addressed as 59 Thomas Court, would that mail get rejected?
Everybody don't get no mail there.
Okay. Thank you.
Everything's in Centerville.
It's got to go to a P.O. box.
Yes.
Okay.
We can't get no mail because we don't have a mailbox.
All right, but she's asking, if someone mailed a letter to 59 Thomas Court, Centerville, would they put it in Mr. Kloppenstein's post office box? Or would it simply be returned to sender, or do you know what happens to it?
No, I don't.
And you don't work for the Postal Service.
Postal Service guys.
There was also a second mailing, which was also sent to that address. And all the court proceedings have that address. All right, thank you. You can step down. Is there anything we can accomplish between now and 5 o'clock?
The only other witness, Your Honor, that would be testifying is Ms. Vela.
Yes, and I'm not sure we can do that in 45 minutes. Now, one of the problems is I don't have large blocks of time often available. I blocked this day. I'm also going to be covering some of Judge Stutzman's matters. I think I'll be trying a case in May. But I did look at the calendar today. I have Friday afternoon, May 8th, 4 hours to continue this matter.
I am unavailable from May 1st
Of course you are.
to May 18th.
Until May 15th?
18th.
18th.
I hope it's for something fun rather than for health reasons.
We are taking my dad on a scuba diving trip.
Scuba diving?
Are you certified?
I've been certified since I was 12.
That's phenomenal. You and my brother should talk.
I would love it.
That would have been too convenient. I don't want to stretch this out for weeks and weeks, which it's going to. This is going to take us 3 days to try this, and I don't have that luxury.
I don't imagine we would need more than 3 hours. They've got one witness.
I have some time available later in May, but that's what I'm trying to. Let me see what I got. How about Friday, May 22nd in the afternoon?
Oh, no. I believe that's my nephew's graduation. I promised that we couldn't, that I would go to.
It's also the Friday Memorial Day weekend, Your Honor. I don't know.
No, yes, it is. Yeah, that's right. Yeesh.
Indeed, I've put in a PTO request for the 22nd. Just to be honest, Your Honor, if you ever want to see me walking again, you'll.
No, I'm not going to interfere with your nephew's graduation, but it is certainly problematic. Jeez. Friday, May 29th.
That, whatever, if I have anything, Judge, I will make it work.
That's a long ways away. It's a whole month away. And I could possibly, it doesn't matter, you're gone in May, effectively.
There's no allegations of unpaid rent.
I understand.
There's no immediate.
It's a long time for old people like me to remember.
These proceedings that I could not locate copies of the jail calls. Mr. Coleman responded that somebody at my office signed for them on January 30th. But I don't know where they are. So I need an opportunity to.
For clarification purposes, Judge, he emailed me, was it yesterday or the day before yesterday?
No, it was, I believe it was last week.
Here's what I did. I responded to his email. I think it was no more than 2 days ago. And I told him specifically who signed for it because I've got a copy of it. Nikki Neal, who represented that she was from his office, signed for it on January the 30th of 2026.
Nikki. Okay. Nikki, where are the papers?
And so,
and I have a copy here, need be.
Nikki, we need
all right, we're gonna need to go forward. If that was signed for, I'm not, whatever happened. Let's get the jury back in, please.
Here we go. We're going to move forward with the sentencing.
Yes.
This is.
She has the right 15.
Yeah, you got the right.
Yeah, she has the right 15.
Cross me, sir.
That's the indictment that we put down with the fund. Remember that 16?
Defendant didn't look too shook up on being convicted. Like he sort of knew it was coming. He did, after all, admit to having a gun, so. "12 members of the jury now. The one alternate has been released." I keep walking back and forth and back and forth. Take your seats. Pop a squat. And here we go. Judge?
All right, let the record reflect the jury seated, state's attorneys present, defendant and defense counsel are present. Mr. Coleman?
The state calls Captain Michael Ponder.
Captain Ponder.
Think about that for a while. Captain Ponder called to the stand.
And for the record, since the jury's in, states 15 was admitted, I think, while they were gone.
Need that fan to be pointed at me a little more.
Good afternoon, sir. Can you please raise your right hand? Do you swear or affirm the testimony you're going to give in this trial will be the truth, the whole truth, and nothing but the truth? Thank you, sir. You can have a seat.
Do we get to see him, Judge?
You may proceed.
Thank you, Your Honor. Would you please state your full name for the record, please?
My name is Captain Michael Ponder.
And Captain Ponder, how are you employed, sir?
I am the custodian of records at the Jefferson County Correctional Facility.
And that's what we refer to as the jail, Jefferson County Jail, right?
Yes, sir.
And the jail is equipped or outfitted with recording equipment that is capable of recording phone calls made from the jail by inmates.
Yes, sir.
And these inmates, are they assigned or given a unique inmate number or inmate PIN number that they use to make those jail phone calls?
Yes, sir.
And how long have you been with the jail?
11 years.
And in those 11 years, have you known that recording equipment to be reliable equipment?
Yes.
Capable of making an accurate recording?
Yes.
And did you listen to certain recordings associated with the PIN number for a Romeo Randolph Johnson?
Yes.
May I approach the witness, Judge?
Yes, sir.
And what I'm going to mark as State's Exhibit number 16, I'll hand to you here. Before I mark it, I'll ask you if you recognize it.
Yep.
USB drive?
Yes.
How do you recognize it?
Because after I listened to it, I initially dated it.
Okay. All right. And when you listened to it, it contained 3 separate phone calls from utilizing the PIN number from the defendant, Romeo Johnson. And do you have any reason to believe that those 3 phone calls were any way altered or manipulated or changed?
Yes.
And with regard to those 3 phone calls, were they placed on 3 separate or broken out into 3 separate USB drives?
Yes.
And on those USB drives were what's referred to as subtitles added to the to that particular recording.
Yes.
In other words, words that are scrolling across there.
Yes.
As the recording is played. But for the addition of those subtitles, do you have any reason to believe that the contents, the actual recording, was altered or manipulated in any way?
No, sir.
So I'm going to show you what I'm going to mark as State's Exhibit number 17. Again, USB drive, it's got your initials and the date on it that you listened to it, right?
Yes.
What date's on there for the visit?
4/28/26.
Oh. And for identification purposes, State's number 17 is referred to, it has a label on it that says number 3, but it is referring to a phone call ending in 1802. So that's State 17.
We don't need the whole phone number.
18 will be another USB drive. And does it have, again, another one of the 3 recordings broken out with subtitles?
Yes.
Initials, the date that you listened to it, right?
Yes.
Any reason to believe that it has been altered or manipulated other than the addition of the subtitles?
No, sir.
I'll mark that as State's Exhibit number 18. And for record purposes, I'll represent to the court that it bears a label that says number 4, and number 4 corresponds to the phone call ending in 02-0.
8675301.
The 3rd phone call here from that original USB that contained all 3 that has the addition of subtitles. And does it also bear your initials and the date you listened to it?
Yes, sir.
And when you listened to it, any reason to believe that it had been, other than the addition of the subtitles, altered or materially changed?
Can't we just stipulate these?
And I'll mark that as State's Exhibit number 19.
Just stipulate.
And for record purposes, that USB drive has on it a label that says number 5, and number 5 corresponds to the identifier given by the jail ending in 07 dash.
It says unique identifier, not a phone number.
With that, Your Honor, I will tender into evidence States 16, 17, 18, and 19, which have all been previously provided to defense counsel in discovery.
And request to
for the
publish.
record, I have provided him with a written version of the subtitles, and I'll tender to him for his inspection.
Or the other witness?
Sure.
All right. Captain, for today, have you had any interaction with this defendant?
Yes, sir.
When there are calls made from the jail, is it the case that some inmates will, because of various restrictions, use other inmates' PIN numbers to speak to people?
Yes, sir. It does happen.
Okay. And with regard to these subtitles that were added to these calls, did you add those subtitles?
No, sir.
Can you sit here and tell this jury and this court with 100% certainty that these subtitles are exactly what's said on that video or that recording?
No, sir.
And
no. Who made them?
With regard to the recordings, what the state would want to offer as statements of the defendant are statements of the other person on the recording also included in these recordings.
Yes.
All right.
So that's hearsay?
Foundation, hearsay, and relevance.
Mr. Coleman?
There's my understanding of the hearsay objection, at least, is that is not unlike with a 911 call, where the hearsay objection is inapplicable, as it is a jail phone call that courts routinely admit into evidence. It is certainly non-testimonial, and it is contextual, so that the trier of fact can understand what the defendant is actually saying and responding to.
So what about I'm going to overrule the objection with regard to hearsay. I'm going to overrule the objection with regard to relevance. I'm going to overrule the objection, all objections on 16. 16 is admitted. My issue is with the subtitles and who put the subtitles on, and if that's, I feel like that could be a potential issue.
I added the subtitles, Your Honor, and I provided a copy of the timestamp and what the word that I've added to the video.
No. The prosecutor, I put the words on that I want you to think were said.
Provide that to defense counsel.
So I received this just a few minutes ago, and as I represented to the court earlier, I was looking for these calls prior to this proceeding beginning. I advised counsel that I could not locate them. Counsel's response to me was to say that somebody from my office signed for it on January 3rd.
So I'm not worried about that. The subtitles themselves, you were given that just today?
Just now.
Okay, so I'm going to sustain the objection to 17, 18, and 19.
Your Honor, I will say this. Those phone calls are almost indiscernible without those subtitles.
All the more.
All the more.
I think that's...
All the more.
If you can discern them, then the jury will have to do their best to discern them as well. So 17, 18, and 19, I sustain the objection. 16 is admitted.
The prosecutor heard what he wanted to hear in those ones. He might have been right, but I'm sorry, that's not how you do things.
Permission to publish, sir?
Yes, sir.
Okay, we're listening to some jail calls. Here we go. Hope the audio's good.
And you can also, so the way it works right now is we just have sound coming out of this TV.
Oh, no.
So if you want, you can get the I don't know where it would sound better, if it would sound better coming from behind them also. Sometimes that gets a little,
Echoey.
just try it and let's see where it sounds best, but we can adjust because the sound's actually coming from the TVs, not the speakers in the ceiling.
It's going to be terrible audio. We're not going to understand a word of this. We're going to need the subtitles from the prosecutor. Red pen, you don't want to translate these? Did she kill the mics? Please tell me you didn't kill the mics for this.
Judge, I think this is what I'd like to do. It's in evidence. The jury can listen to it. I'd like to just argue what I believe said on the video. And then
No!
they can listen to it.
That's
if that's okay with the court.
No.
It's in evidence. They can have that
Yes,
opportunity.
ma'am. Phil, I think that's what I'll do. Thank you. I have no further questions for this witness, Judge.
Thank you. Any questions of this witness?
Just want to follow up on something. You stated that inmates will sometimes use other inmates' phones due to various restrictions. Are you absolutely certain, as you sit here today, that one of the voices contained on each of those calls belongs to the defendant, Romeo Johnson? Move court to reconsider, Your Honor.
Can I go to the weight, not the admissibility?
I agree. Anything else?
No, Your Honor.
He said
All right,
they
thank you,
might not
sir.
even be him.
Stay rested this.
All right, thank you. Any,
Judge, may I reopen? Mr. Smith pointed something out to me. Is these, just these, out of an abundance of caution, the actual judgments that I do have, just want to bring in, that's okay. 21, 21, 22, 23. Okay.
This prosecution and the
I'm marking
defense
6.
have been a mess.
1, 2, 3, and for purposes of the record, I'm tendering to the defense counsel for his inspection. Certified copies of certain judgments.
So same objections as previous.
would you also please hand me that, is it 15, the big one?
This, I think,
Hand me 10, no, 11 and 12, please.
10, 11, and 12.
Thank you very much. Appreciate it. Should I donate to you?
I don't know what that sound was. Maybe somebody sneezing? The jury should be going out and deliberating, and it should be very quick. They already have their foreman. That's what took them 60 minutes last time to figure out who the foreman was. Judge is reviewing everything.
Hey, based on the identifiers that have been already looked at from states 10, 11, 12, and 13, and 15, all of the identifiers also match on states 20, 21, 22, and 23. They all have the same state identifier number of 07111-416, the same names and or AKAs with a couple of variances of some additional AKAs, and everything else again matches. So that objection is overruled. With regard to 20, 21, 22, and 23, they're all admitted.
Not looking good, my friend.
All right.
No further state rest in question, Judge.
Thank you,
We rest
Mr.
again.
Wilkerson. Any witnesses?
Yes, rest, Your Honor.
All right, so ladies and gentlemen, what that means You now have heard the evidence with regard to punishment. I've got the charge prepared. I just haven't been able to give it to the attorneys yet because things moved a little quickly. This should not take longer than about 10 or 15 minutes. I'm going to give it to them, let them go through it. It's pretty straightforward. So it's 3:35, we'll try to get started close to 3:45, 3:50. So just kind of stay close if you can. For everyone else, please remain seated. You're excused for about 10 or 15 minutes.
Jury's out for another walk. They're getting their 10,000 steps today.
All right, I'm about to print 3 copies.
Judge orders pizza. Make it 3 larges. Pepperoni. Do we dance again for a sentence verdict? This jury is going to be home in time for dinner. Red Pen, you called this one. You saw the writing on the wall. Once again.
All right, the copies of the charge are printing now. They'll bring them in. You guys take a look at them. Everything. It's pretty straightforward. So, shoot. I just saw something.
Oh, now I need to fix it.
Okay. All right, so we'll be in recess for about 10 or 15 minutes.
10 or 15. That's enough time to go up to Thurston County. We can make a quick visit up to Thurston. Let's see.
$1,500 total. All right. So, what was your question? No, just set it directly onto the 1:30 calendar. Yeah. All right, Mr. Higgins, then we're all done for today. You can let the corrections officer know and they'll take you back.
All right, thank you.
Okay. I'll get all those orders done at the end since he's got a lacy amount of cases.
I told my attorney to please look into what I told her to look into.
Yes, yes, Mr. Haggins, I will.
Thank you.
Okay, that deserves a rewind.
Okay, and then we'll switch.
Let's go back just a little bit and see what's up with Mr. Higgins here.
There at Nisqually Lacey, and sir, what's your name, please?
Edward Higgins.
Just.
I didn't.
Oh, sir, over at Nisqually Lacey, what's your name, please?
Edward Higgins.
Little bit louder.
Edward Higgins.
Okay, thank you. All right, Mr. Higgins, you're here today in court for a number of cases that are in a number of positions. So I'll start with new cases. You're here to be arraigned on charges of trespass in the first degree that Lacey alleges occurred on April 23rd, theft that Lacey alleges occurred on April 28th, and then another count of theft and criminal trespass that the city alleges occurred on April 27th. All right, Ms. Grisco.
Thank you, Your Honor. Amy Garisco for the record. In talking with Mr. Haggins, I did have some 1077 concerns. Mr. Sharp and I had a brief conversation, and I have sent that to him. He has signed it. I have signed it as well, and I believe that we sent it to Madam Clerk.
For an evaluation, sounds like competency.
Okay. So you want to have a competency assessment before he proceeds any further?
Yes, Your Honor.
All right. And Mr. Higgins is also pending trial on some other matters, so we'll add all the pending cases to the same competency assessment.
Thank you, Your Honor.
Okay, his next court date is already scheduled for May 19th.
Yeah, there may be something scheduled May 7th already. I think he had pending out of custody arraignment scheduled. We caught those cases today and added them to today's calendar, so maybe it was stricken.
Yeah, it was probably stricken then if you did that, but May 19th is probably about the right amount of time anyway.
So it's only going to be stricken until May 19th? Or do I have a bail?
Probably not with the competency hearing.
I'll leave that date set and convert that from trial confirmation to competency hearing.
Your Honor, city does have a bail and conditions request. I can establish probable cause on the new cases if there's not a stipulation.
Could I please be released?
Doesn't work.
Mr. Sharp, could I please be released and I'll do a daily check-in or anything to your
Ms. Garisco, is there any stipulation of probable cause to the new charges that I read out here earlier?
Your Honor, we'll stipulate a probable cause for this hearing.
Okay, Mr. Sharp then.
Thank you, Your Honor. And I do want to just respond, let Mr. Haggins know I can't interact with him directly. He needs to talk with his attorney. Your Honor, city's asking for $250 bail on each of these, pending evaluation. We now have 5 cases open from the same location, Best Western. He has 2 active warrants out of 2 different jurisdictions with this ongoing behavior, which is repeated violations of release conditions. City believes that he's very unlikely to appear for future hearings with all those violations, as well as those warrants and the ongoing violations themselves justify bail. So $250 on each is a pretty modest request. If the court's inclined to impose conditions, we're also asking for law-abiding behavior, that he not have any contact with Best Western Hotel, also Safeway on Marvin Road.
All right, Ms. Garisco, what's your position?
Your Honor, with the high volume of out of custody evaluations, we would ask for him to be given the evaluation in custody. I believe it's at 14 days at this statutorily, but no objections at this point.
Then I'll set bail at $250 on each case, and we'll get all the cases sent to the evaluator. And I would guess that we're probably going to see our evaluation before May 19th, but I'll keep that May 19th date as a placeholder.
How much does that come to? How much time does that come to? I mean, how much does the bail amount to?
$1,500 total. So, what was your question? No, just set it directly onto the 130 calendar. Yeah. All right, Mr. Higgins, then we're all done for today. You can let the corrections officer know and they'll take you back.
All right, thank you.
All right, now we're caught up.
Okay. I'll get all those orders done at the end since he's got a lacy amount of cases.
I told my attorney to please look into what I told him to look into.
From the state of Georgia.
Yes, Mr. Haggins, I will.
Thank you.
Okay, and then we'll switch over to Nisqually Olympia. Sir, what's your name, please?
Hello, sorry, my handcuffs aren't locked. My apologies.
Can you tell us?
What about your handcuffs?
Sir, your name, please.
So my name, Kyle William Goodpasture, sir. Sorry, my handcuffs aren't locked. It's hard to talk now.
Your Honor, for the record.
Yeah, go ahead.
On behalf of Mr. Goodpasture.
All right, Mr. Goodpasture, this is your pre-trial hearing, and Ms. Stewart, your attorney's here, so I'm going to turn to her. Ms. Stewart?
Your Honor, we have quite a few matters to resolve today, so you should have some changes of plea, and we're going to proceed. I've met with Mr. Goodpasture. We've gone over all of the charges that we'll be addressing today, the elements of the crimes, the maximum penalty, the minimum, or not minimum, but the consequences. What the city will be recommending, and satisfied my obligation under Padilla Sandoval and inquiry. He's unable to meet any of his legal financial responsibilities right now. And then I'll let you know more about him during colloquy after the plea.
Okay. All right, so these plea statements account for all the case numbers except for the one that ends in 068. Is that one going to be resolved as well?
I hope I did everything correctly, Your Honor. Mr. Carver, is that correct?
That's the matter that's going to be dismissed upon plea.
Okay, gotcha. Okay. All right, Mr. Goodpasture, I have a number of guilty pleas here.
Yes, sir.
It looks like you're pleading guilty to violation of controlled substances, 2 counts, resisting arrest, and pedestrian interference. Is that what you want to do, is plead guilty to those charges?
Seems like the best choice to me, sir. That is what I got.
Have you reviewed your guilty plea statements with Ms. Stewart?
Yes, I have. Yes, I have. And she's a fine one at that. Yep.
Okay.
Yes, I have, sir. I was just saying that
You've reviewed them with her? All right. Do you have any questions about pleading guilty?
I mean, pointless questions. Yes, Your Honor. I mean, just being short. Yeah, you're fine. Everything's good. Yeah, I understand my choices. I wish I could change them, but this is the best choice for me right now, sir.
All right. All right. Then, Mr. Goodpasture, by pleading guilty to all of these charges, you're waiving your rights in these cases. And that means the right to go to trial in these charges, to have the prosecutor prove each charge beyond a reasonable doubt to a jury, the right to call witnesses to court who could testify in your defense, the right to hear and question witnesses who testify against you. You give up the presumption of innocence on these charges and the right to appeal your convictions to a higher court. Each one of these charges has a maximum penalty. So pedestrian interference and resisting arrest have maximum penalties of 90 days in jail and a $1,000 fine. And the controlled substances charges have a maximum penalty of about 180 days in jail and a $1,000 fine. Now, no matter what sentence anyone is recommending I give you on these, then you need to understand I don't have to follow the recommendation and could impose up to the maximum sentence for each one. Now, did anybody make any threats or any promises to get you to plead guilty to these charges?
No promises or threats, just the honest, reality of things, sir. And what seems realistic, what doesn't seem realistic. And my faith in the honor system and the justice system, sir. That's about it. That's the only thing. No one has threatened or made any promises, sir. Sorry, I don't mean to talk extra with my abilities.
Okay. All right, and there are some statements attached to your pleas. So the pedestrian interference statement says on August 7th of 2025 in Olympia, I was resting on the sidewalk in violation of Olympia Criminal Code, which limits hours the sidewalk is available to rest on. Is that your statement?
Yes, sir.
Okay, and even though your signature doesn't appear on these, I'm gonna indicate on the plea statements you're adopting that statement.
Thank you, Your Honor.
All right, and as to the pedestrian interference guilty plea under 2025666, I will accept that plea. Okay, and then the guilty plea statement for resisting arrest and controlled substance also has a statement attached to it. And it says on April 12th of 2026 in Olympia, I knowingly possessed methamphetamine and resisted a lawful arrest. Is that also your statement?
Yes, sir, Your Honor.
All right, in that case, I will accept your guilty plea to that charges, those charges as well. Finally, case 2025014, the statement attached to that plea. It says on January 5th of 2025 in Olympia, I knowingly possessed methamphetamine. Is that also your statement?
I believe so, sir. Yes, Your Honor.
Okay, and I will also accept your guilty plea as to that charge. All right, and then Mr. Carver, can I hear from the city first?
Your Honor, in their might have been some confusion because I think he had at least one of these cases were sort of add-ons and such. The city's dismissing 2025-666 and 2025-1068. The 666 is the pedestrian interference charge, so that the city's moving to dismiss that one as well.
Then we'll strike the
Pedestrian
acceptance of
interference.
the
That's
guilty
just blocking
plea and
someone on the
enter an
sidewalk.
order of dismissal.
Mr. Goodpaster's offenses seem to be substance abuse related. As such, the city's going to be asking for that
he whistles
chemical dependency evaluation and treatment. He's not to return to the Quint Street Village at Union and Plum. And he's to abide by an exclusion order. And that was I submitted that to the in custody desk. It may not have reached the clerk yet. But that exclusion order will be good for 1 year.
Is that better? I took the S's down.
The idea here is that we're going to keep him out of the areas where he has access to narcotics, and there is a prevalence of narcotics in the city.
Yes, there are, fortunately.
All right, Stuart.
Yes, Your Honor. I spoke with Mr. Goodpasture. He was sober for a period of time, and then he relapsed. So you see a short period of time, or a period of time where he didn't have police contact. He was he went to a different city to avoid, as Mr. Carver is indicating, avoid areas that are high in narcotics, and found that it's worse other places. So now he's returned to resolve all of his criminal matters. To get when he gets out of jail, he
We have to jump back.
that he's going.
Everyone's coming back in. Sorry, we have to bail on Tumwater. Going back to our main case here in Beaumont, Texas. I know we've been jumping around a little bit.
All right, state's attorney's present, defendant and defense counsel are present. Before we bring the jury in, is there anything we need to take up, Mr. Wilkerson?
Your Honor, defense would move to reopen the case briefly to present testimony from the defendant in this case.
No objection.
All right, I will allow you to do that. I have given you both a copy of the court's proposed charge. Any issues, requested additions or objections to that charge?
Nothing stated. Nothing from the defense, Your Honor.
I wouldn't imagine that anything would change after that testimony. And so my goal would be to do that, read the charge, and go straight into closing argument without another break.
Yes.
Okay, you can bring the jury in.
Bring the jury.
This case never ends. For having the record short deliberation, it's taken forever. Jury's coming back in. We're making some progress, guys. The jury has to make a recommendation as far as the sentence, and since they were able to figure out the guilt so quickly, I don't think it'll be too difficult to do this next part. Probably less time, honestly, less time. Let's see what happens here. They file back in. Like I'm never serving on a jury again. I have to walk for days. Jury's here. Here we go. Judge, all you.
All right, let the record reflect the jury seated, state's attorney's present, defendant and defense counsel are present. And ladies and gentlemen, while you were out, the defense has requested to briefly reopen the punishment phase and allow his client to testify. That was without objection from the state, and so I'm going to allow him to do that. Mr. Wilkerson, Mr. Johnson, you can come on up and please keep it brief.
Yes.
Thank
Thank you very much. Mr. Johnson, you, well, you have been incarcerated since the inception of this case, is that correct?
Yes, sir.
In the Jefferson County Correctional Facility?
Yes, sir.
Can you just briefly kind of explain the personal growth that you've experienced and realizations you've had since you've been in custody?
Oh, about in 2024, maybe around like February, I changed. I really changed, gave my life to Christ. But I was in and out, one foot in this, one foot doing that. So when I got incarcerated the first time, it really was an eye opener. Like, I don't know if God tested me through this or whatever it was, but as I was going through it, I've matured, I've developed, I've been in my word. All I do is read it. Whole Bible study Monday, Wednesday, and Friday. I mean, that's not a thing, just be, but that's what I do. And it's just really matured me, made me see things from a different perspective.
The jury has heard a lot about some past criminal conduct. Back during most of that conduct, were you were you a person with a substance abuse disorder?
Yes, sir.
And did, not that, and I think you realize, well, you don't think that justifies what happened in the past, do you?
No, sir.
You take full responsibility.
Yes, sir.
And I believe you testified earlier that you, aside from the present allegations, in the past, when you've messed up, you've kind of accepted responsibility for that. And so in terms of the changes that you've undergone, do you believe that once you are discharged, however that may be, whether parole or otherwise, that you will be able to continue on the good path, so to speak?
Oh, yes, sir. Well, whether, found me guilty or not, I pray for each and every last one of you. I thank God for you, for your time. And yeah, I've just really grown. So it's no grudges. It's no, it's acceptance. I accept because that's what God would have me do. And that's what I would do. And yeah, once I get out, I'm trying to be productive in the community. I see a lot of things on TV with the violence, with the, no guidance. At one point, me and my brother, when I did get out, we had started to put the guns down, pick the gloves up, and we had youth coming, and that's what they was doing. They was training, trying to show them discipline. And when he furthered it along, he had little league things, but I feel that they was positive role models to me. I mean, some situations was kind of beyond my control, but I was, you could say, wrong place, wrong time type of thing. And but I accept all things. I accept it all. And I'm growing. I grow from it. I'm better. I give God the glory. So,
And with regard to during the guilt innocence phase of the trial, we heard from Mr. Cooper that that life that you were engaged in back when most of your charges arose. Is that when you got to know Mr. Cooper?
I've been on Daryl for over 15 years. But what really got me was how Daryl came on the stand as if I was some modern day Billy the Kid or something, or just taking him down or taking his money or hurting him in any kind of way. Me and that man never had a relationship, but I've never touched him. I've never pulled a weapon on him. But I mean, who knows what he's dealing with to come up here and say things like that. I'm not mad at him either. It's just, who knows what he had going on, who knows what he was told. It's just, it's acceptance. I mean, now I have to be dealing with that and trying to, face that and trying to get people to see that, well, I've never did anything to this man, as if he said I had a gun, but said he heard a slide, but it was no gun that he ever seen on me. Only thing he said that was truthful was that I was there. And that's one thing that really gets me, because when the dude did whatever he did to Mr. Cooper, I was sitting there, but just as shocked that he was, I was like, what are you doing? As you can see, he's an old man. He has no money. You see that now. I mean,
Mr. Johnson, can you describe briefly your support structure?
I have a family. Y'all seen them earlier. If y'all paying attention, look like Suge Knight. That was my brother back there. That's my oldest brother. It's 10 of us. Most of them work. But I have my mother. She's still living. My father, he's still living. They're older. They're elderly. My nieces, my two nephews just went to the army. One of my nephews is training to be a nurse, so doctor or something like that, a heart surgeon. And well, the family is, we always been a close knit family. It's 10 of us. We always been
Nurse, doctor, heart
close knit.
surgeon.
I call every last one of them. I call my mom. We always just been tight. We just, catch around and see us all outside and think it's a party, but it's not. It's just a family get together.
You indicated that in the not too distant past you have rededicated your life to God, I believe is what you said.
Yes, sir.
Do you have a particular place of worship that you intend to attend when you are discharged or released?
Yes, sir. Macedonia Baptist Church is right off Gladys. It's small, but I've been to it a couple of times. It's powerful. Good word in there. The spirit is moving in there. And that's a place that has accepted me, and I still call the pastor. And he prays with me, and he give me things that I give back to others, kind of comment, feedback thing.
Careful how you say he gives me things that
just
I
a
deal
place
to
that
others.
I'm gonna go
That's
when I get out.
I want to ask you about something in part because of what the law specifies with regards to sentencing in these matters. Do you recall the date that your incarceration began?
Yes, sir. On my birthday, I went, reported, and turned myself in because I was a suspect in another case, and I voluntarily called them, turned myself in, gave my statement, and it's been since September 14th, 2024.
And so, while you have been in custody at Jefferson County, have you do you earn money when you're in there?
Oh, I work, and they do pay weekly. I worked at maximum security, where Captain Under is over it. I worked at maximum security. They pay you $8 a week. I mean, they're entitled some things that I'm pretty sure a lot of people wouldn't want to do, but yeah.
Right. And
$8 a week.
In terms of ability to pay a fine, because you are in custody now, have been since 2024, and will continue to be until such time as you are discharged, everything that you're dealing with is being cleared up. Do you have the ability to earn the funds that would pay a fine of up to $10,000?
No, sir, no, sir. I wouldn't be able to obtain them funds. If I had $10,000, we don't know anything. You probably fighting this from the world, or I'm trying to settle this from the world, but no, sir, there's no way for me to pay $10,000.
I'll pass the witness, Sherman.
Thank you, Mr.
No
Wilkerson.
questions for this defendant, Judge.
Thank you, Mr. Johnson. You can have a seat. Any other witnesses?
Ms. Ratch.
Thank you, Mr. Wilkerson. Does the state, you have the right to, well, nope, I get to read the charge now. All right, so that is it then for punishment evidence. At this time, I'll read the court's charge and then you'll hear argument by counsel. Cause number 25, DCCR 1626, the state of Texas versus Romeo R. Johnson, AKA Romeo Randolph Johnson, jury instructions. Members of the jury, you have found the defendant, Romeo R. Johnson, AKA Romeo Randolph Johnson, guilty of the offense of unlawful possession of a firearm by felon.
Possible
Now
2
you
to
must
20
determine
years.
the punishment to
you
be
could serve.
imposed on the defendant. The parties will soon present final arguments on what? Am I doing
You
wrong?
argue first?
No. I read the charge and then you argue because y'all talk about the charge.
Yeah, she's right. You're wrong. She's right.
The record get that?
Yeah.
It's been a long day, but
20 is because of a
Okay.
prior felony, which is weird.
the
because
parties will
a
soon
felon
present
in
final
possession
arguments on
requires you to be a
punishment.
prior felon.
Before they do so, I must now give you the instructions you must follow in determining the defendant's punishment. You will have a written copy of these instructions to take with you and to use during your deliberations. I will first tell you about some general principles that apply in all criminal cases. Then I will instruct you on the rules that must control your deliberations. Finally, I will tell you about the specific law applicable to this case. General principles. As the jurors, you review the evidence and determine the facts and what they prove. You judge the believability of the witnesses and what weight to give their testimony. In judging the facts and the believability of the witnesses, you must apply the law provided in these instructions. In determining the sentence to be imposed on the defendant, you may take into consideration all the evidence admitted before you. This includes the evidence admitted during the first stage of the trial concerning the defendant's guilt, as well as any evidence admitted during this punishment stage. The evidence consists of the testimony and exhibits admitted in the trial. You must consider only evidence to reach your decision. You must not consider, discuss, or mention any other thing that is not evidence in the trial. You must not consider or mention any personal knowledge or information you may have about any fact or person connected with this case that is not evidence in the trial. Statements made by the lawyers are not evidence. The questions asked by the lawyers are not evidence. Nothing I have said or done in this case should be considered by you as my opinion about the facts of this case or influence you to vote one way or the other. You should give terms their common meanings unless you are told in these instructions that the terms are given special meanings. In that case, of course, you should give those terms the meanings provided in the instructions. While you should consider only the evidence, you are permitted to draw reasonable inferences from the testimony and exhibits, if those inferences are justified in the light of common experience. In other words, you may make deductions and reach conclusions that reason and common sense lead you to draw from the evidence. You are to render a fair and impartial verdict based on the evidence admitted in the case under the law that is in these instructions. Do not allow your verdict to be determined by bias or prejudice. You may, if you wish, examine exhibits. If you wish to examine an exhibit, the foreperson will inform the court and specifically identify the exhibit you wish to examine. Only exhibits that were admitted into evidence may be given to you for examination. Certain testimony will be read back to you by the court reporter if you request. To request the testimony be read back to you, you must follow these rules. The foreperson must make the request in writing and sign it. That request must, 1, state that it is requesting that testimony be read back. 2, state that you have a disagreement about a specific statement of a witness or a particular point in dispute. And 3, identify the name of the witness who made the statement. The court will then have the court reporter read back only that part of the statement that's in dispute. During the trial, you heard evidence that the defendant may have committed wrongful acts that did not result in any criminal charges or that did not result in criminal convictions. You are not to consider any evidence of any particular wrongful act unless you find beyond a reasonable doubt that the defendant did, in fact, commit that wrongful act. Those of you who believe the defendant did the wrongful act may consider it. You must arrive at the amount of punishment by a full, fair, and free expression of the opinion of the individual jurors. You must not decide punishment by lot or by chance. For example, you may not agree beforehand to be bound by the result of a procedure by which each juror gives the number of years the juror thinks should be served. These are then added and the result is divided by 12. To reach a verdict, all 12 of you must agree. Rules that control deliberations. You must follow these rules while you're deliberating and until you reach a verdict. After the closing arguments by the attorneys, you will go into the jury room. The 4 persons should conduct the deliberations in an orderly way. Each juror has 1 vote, including the 4-person.
Defense objected
the
to
4-person
that.
must supervise the voting, vote with other jurors on the verdict, and sign the verdict sheet. While deliberating and until excused by the trial court, all jurors must follow these rules. 1, you must not discuss this case with any court officer or the attorneys or anyone not on the jury.
We'll talk about it in just a second.
2, you must not discuss this case unless all of you are present in the jury room. If anyone leaves the room, you must stop your discussions about the case until all of you are present again. 3, you must not communicate with the judge. You must communicate with the judge only in writing, signed by the 4-person, and given to the judge through the officer assigned to you. 4, you must not conduct any independent investigations, research, or experiments.
I'm going to mute her for a
5,
second.
you must tell the judge if anyone attempts to contact you about the case before you.
While she's explaining this to them, the thing I have an issue with is she said, during this case, you may have heard evidence that the defendant committed offenses which he may not have been charged or convicted of. That's the murder charge. And she told the jury they could consider that if they believed he actually committed those. This jury could look at him and say, I think he actually did the murder, and I'm going to consider that in this case. That has got to be appeal.
Once before. The defendant has pleaded that this accusation is not true. The range of punishments from which you must assess the defendant's punishment depends on whether you find the state has proved the prior conviction accusation. If the state does not prove the accusation of a prior conviction is true, this offense is punishable by 1, any term of imprisonment for no less than 2 years and no more than 10 years, or 2, any term of imprisonment for no less than 2 years and no more than 10 years, and a fine of no more than $10,000.
2 to 10.
If the state proves the accusation of a prior conviction is true,
here's where the
this
extra 10
offense
comes
is
in.
punishable by 1, any term of imprisonment for no less than 2 years and no more than 20 years, or any term of imprisonment for no less than 2 years and no more than 20 years, and a fine of no more than $10,000. Robbery is a felony offense. The state must prove beyond a reasonable doubt the prior conviction accusation. The length of time for which a defendant is imprisoned may be reduced by the award of parole. Under the law applicable in this case, the defendant, if sentenced to a term of imprisonment, may earn early parole eligibility through the award of good conduct time. Prison authorities may award good conduct time to a prisoner who exhibits good behavior, diligence in carrying out prison work assignments, and attempts at rehabilitation. If a prisoner engages in misconduct, prison authorities may also take away all or part of any good conduct time earned by the prisoner. Under the law applicable in this case, if the defendant is sentenced to a term of imprisonment, the defendant will not become eligible for parole until the actual time served plus any good conduct time earned equals 1/4 of the sentence imposed. Eligibility for parole does not guarantee that parole will be granted.
So it has to serve
It cannot
75% of
accurately
the
be
sentence.
predicted how the parole law and good conduct time might be applied to this defendant if he's sentenced to a term of imprisonment, because the application of those laws will depend on decisions made by prison and parole authorities. You may consider the existence of the parole law and good conduct time. However, you are not to consider the extent to which good conduct time may be awarded to or forfeited by this particular defendant. You are not to consider the manner in which the parole law may be applied to this particular defendant. Application of law to facts. You must determine whether the state has proved beyond a reasonable doubt 3 elements of its accusation of a prior conviction. The elements are that 1, the defendant was convicted on March 9th, 2015, and cause number 14-21127 in the District Court of Jefferson County, Texas, and 2, this conviction was for robbery, a felony, and 3, this conviction became final before the commission of the offense for which the defendant was convicted in this trial. You must all agree on elements 1, 2, and 3 listed above. If you all agree the state has failed to prove beyond a reasonable doubt 1 or more of elements 1, 2, and 3 listed above, you must find the prior conviction accusation is not true. In this event, you are to determine and state in your verdict 1, the term in prison to be imposed on the defendant for no less than 2 years and no more than 10 years, or 2, the term in prison to be imposed on the defendant for no less than 2 years and no more than 10 years, and a fine of no more than $10,000. Excuse me. If you all agree the state has proved beyond a reasonable doubt each of the 3 elements listed above, you must find the prior conviction accusation is true. In this event, you are to determine and state in your verdict 1, the term in prison to be imposed on the defendant for no less than 2 years and no more than 20 years, or 2, the term in prison to be imposed on the defendant for no less than 2 years and no more than 20 years, and a fine of no more than $10,000. And then that has my signature on it. And then the final page is the verdict sheet. There's 2 different options. The top is titled Verdict, Accusation of Prior Conviction Not True. We, the jury, having found the defendant, Romeo R. Johnson, aka Romeo Randolph Johnson, guilty of the offense of unlawful possession of a firearm by felon, find that the accusation of a prior conviction has not been proved true. We assess the defendant's punishment at, and then there's 2 options. You'll select 1. The first, imprisonment in the Texas Department of Criminal Justice for a term of blank, 2 to 10 years and no fine. Then the second is imprisonment in the Texas Department of Criminal Justice for a term of blank, 2 to 10 years, and a fine of blank, $10,000 or less. Then the second option is verdict, accusation of prior conviction true. We, the jury, having found the defendant, Romeo R. Johnson, aka Romeo Randolph Johnson, guilty of the offense of unlawful possession of a firearm by felon, find that the accusation of a prior conviction has been proved true. We assess the defendant's punishment at, and then
prior
you would
conviction
select
is
one
the
of
robbery.
The first is imprisonment in the
wording is
Texas
bad.
Department of Criminal Justice for a term of blank, 2 to 20 years and no fine. And then the second is imprisonment in the Texas Department of Criminal Justice for a term of blank, 2 to 20 years and a fine of blank, $10,000 or less. Each of those also has the signature line and the line for the printed name of the foreperson. So you pick one and then you pick one within that one. Mr. Coleman, you have the right
And
to open and close argument.
State was his right to open, reserve your right to close it.
Thank you, Mr. Coleman.
May we approach very briefly? It'll be the last time.
Sure.
Please make it the last time. Okay, I think I understand it now. The wording says, in this trial, you have heard there may have been evidence presented that the defendant committed an offense that they may or may not have been convicted of. That wording is talking about the robbery. The only problem is it doesn't exclude the murder, which they also talked about, which also fits in there. So you could have a jury who sits in there saying, we heard testimony in the trial about the murder, which he was not convicted of. And we were specifically instructed that if we think he was guilty of it, then we can consider it. I don't know how it could be. Actually, I don't think it's about the robbery. It couldn't be about the robbery because it has to be a felon in possession, which means you have to have that conviction. It's got to just be about the murder. That makes it worse. I thought in my head I'd solved it, but no, it doesn't. I don't like it.
All right, Mr. Wilkerson, you may proceed.
Thank you. Ladies and gentlemen, it's been a long few days, and I meant what I said earlier. Thanks for I meant what I said earlier when I told you that what your verdict would be justice. I still believe that. I would be lying if and intellectually dishonest if I tried to tell you anything other than that we're will disappointing the verdict, but you followed your oaths, you followed the law, and ultimately the end result was finding you guilty. So now you have the responsibility, the non-enviable responsibility, in my opinion, of deciding what punishment fits the offense. And when you begin to assess punishment with regard to an offense, what I suggest you or submit to you is that you need to consider all of the circumstances with regard to that offense. And in this particular case, obviously the jury decided to believe that there was a firearm that was exchanged between Mr. Smith and the defendant. But what I would advise you, what I would implore you to consider is the brief amount of time for which the defendant had what you've determined to be a firearm before it was returned to Mr. Smith. As the defendant asserts was the case. And he spoke in terms of the gun, but and so now, with all of that in mind, obviously, you're asked to consider also the defendant's criminal history. And there is no doubt that I'm not going to try to whitewash anything to you that in his young years and leading even up to these incidents, he has had issues with criminal offenses. Those issues have been born of substance abuse. And unfortunately, we find often in our lives that substance abuse is a disease that touches everybody, in some way or another. I imagine we all know someone who has had problems with substance abuse. I know, in my family, that problem existed, and I know my brother would pawn the belongings of myself and other family members, and that was difficult to deal with. But I do think that we know that people who find themselves in desperate situations and are not thinking clearly often do things that they might not otherwise do. And so I would ask you to consider that when you're assessing punishment. You are allowed, of course, to consider the fact that at some point, the defendant at some point after the defendant's time reaches a quarter, his good time and his actual time reaches 1/4 of his sentence, who is eligible for parole. However, we obviously don't know that will in fact be granted. The parole process involves review by a board. They often set off, meaning deny parole, to inmates and, set them for review anywhere from, from 3 years to a year in the future. In some events, they just have to decide to parole someone, but still require them to undertake a 6-month program or 9-month program before getting there. And so obviously none of that is guaranteed. And in terms of doing justice, when we talk about that, it is a process. Sitting in judgment of someone else is not easy. And, I'm not going to presume that any of you have acted in any way except the utmost good faith and strong consideration of all the facts that we're presuming. All I ask is that you continue to do that. That even in considering this defendant's history, that you also consider the circumstances in which that history arose.
It was his birthday.
I think it's important, and I believe defendant in this case is sincere when he tells you that since he's been incarcerated, well, somewhat, nobody who deals with, for instance, substance abuse issues can ever say, I guarantee I'll never do that. Anybody with a substance abuse disorder has another relapse in them, not always another clean time, and so I can't stand here and guarantee to you that, the defendant, once discharged or once paroled, won't ever fall into that. What I can tell you though is I believe that given the amount of time that he has been clean and given the additional time that he'll serve, and given his refocus of his life, that he will come out better rather than worse. And so I ask you to consider all of that in assessing punishment in this case.
Thank you, Mr. Wilkerson. Mr.
Let's
Coleman.
see what the
Thank you,
state
Your Honor.
goes for. Are they
Court,
going to ask for 20?
Counsel, ladies and gentlemen of the jury, your verdict is very much appreciated, and I do believe you've reached the correct verdict. I have no doubt that you get it right on the punishment end. Speaking of the punishment end, at the risk of sounding too jaded, if you've done this for any length of time, this criminal prosecution business, you hear some of the same things over and over. One of those things is that, defendants, inmates often find Jesus in the jail. I truly hope that this defendant has made that transformation. But again, you hear that a lot. There's a saying that if you really want to find Jesus, you know where to find him, you go with the jail. Because that's where the defendants find it. I will submit for your consideration that the jail phone calls that are in evidence are at odds with the defendant's representation that he found Jesus in the jail. They're in evidence. There are 3 phone calls. If you want to listen to them, you can. My interpretation of those from listening to them, again, it's my interpretation. You can listen firsthand for yourself. One of those phone calls, it sounds like he's setting up a drug deal from jail.
Objection based province of the jury.
Overruled.
Sounds like he's setting up a drug deal from jail. He begins by saying, "Hey T, I got in touch with old boy with the cocoa. He said, what you trying to do? I'm trying to get some bread. He said, I am going to do you a fair price for the cocoa. I got my list ready so I can go in there and place my order." I'm summarizing from different portions of the conversation. But he says, "I'm finna let him know that you say, just let him know what the order is." On another jail phone call, there's a portion in there where he says, this is on a different day. He says, "Tell him it's good. I'll let you know about the cocoa tomorrow." And lastly, on the third jail phone call, it's in evidence if you care to listen to it. A little lengthier, but he talks about an individual named Old School. He says, "Old School wanted to get some dope, so I gave it to him. Hey man, Old School want another 20. So old school owed me 40. Binky came in and I was like, I got somebody, got $10. I'm like, all right, bang. Man, I was giving Pooh pounds, ounces, I'm giving them today. I gave, sitting in there, smoking it up. I'm giving Za, I believe, an ounce. I'm sending ounces for 100. Look, brother, just bringing me back 35. Again, these are calls made from the jail while he's sitting in jail, and he's professing to you that he found Jesus while in jail. And I submit to you that's not necessarily consistent with the testimony. Another thing I want you to think about is, I don't want you to think that there was a bait and switch. I know during the jury selection, we talked about the punishment range in this offense being from 2 to 10 for the unlawful possession of a firearm for this defendant. I couldn't necessarily tell you that it was 2 to 20 because he also had another robbery conviction. We feel like that would be prejudicial to this defendant for me right out of the gate to tell you he's got 2 previous convictions for felonies. In other words, the unlawful possession of a firearm by a felon is predicated on that felony evading arrest or conviction that he had. Then there's also the felony robbery that he had, which bumps up that offense from 2 to 10 to 2 to 20. So we feel like would be unfair for the defendant if I right out of the gate say, oh, he's 2 to 20 because of the 2 prior felony convictions. But if you find that robbery conviction true, then it makes his punishment range from 2 to 20. And while we're talking about prior convictions, all of the convictions that I'm relying on are in evidence. And if you wanted to look at them, you can. By way of summary, there's also a summary in there, and I just run through them really quickly. 2004 evading, 2004 robbery, 2007 evading. These are all convictions, mind you, that there was some form of eviction. 2008 evading, 2008 criminal trespass, 2011 criminal trespass, 2011 evading, 2011 possession of a controlled substance, 2012 theft, 2012 manufacture and or delivery of a controlled substance, 2013 possession of a controlled substance, 2015 robbery, 2022 evading, and 2008 unauthorized use of a motor vehicle for which he had his probation revoked. He served 4 years on the evading. He served 5 years on the 2015, or at least he was assessed 5 years on the 2015 robbery, which dovetails into what the ask that I'm making of you is, as you're considering the appropriate punishment in this case, that you consider that criminal history and that you consider the fact that at some point he has served, or at least was assessed, 5 years in prison, and that was not enough to change his criminal behavior. I am of the belief that the punishment should not go down. If you continue to commit criminal offenses, it should go up. And I'd ask you to consider that in assessing your punishment, anywhere between 2 to 20 years. Don't worry about the fine. There's going to be language in there that you can assess a fine of $10,000. Here's the deal. Even if that fine gets paid, it won't go to any victims. It won't even, I don't know what the state does with it. I believe it goes into the general fund. I don't want you spending a lot of inordinate time back there thinking about, deliberating about what the appropriate fine is. I would ask that you not even assess a fine. But what I will ask is that you find at least, at a minimum, that the robbery to be true, and that you assess his punishment within the 2 to 20 range, and that you consider the fact that he may be eligible for parole after serving a quarter of the time of whatever you assess. So what you cannot do, and what the jury charge says you can't do, is you can't, and I'm just going to read it. You cannot consider the existence of the parole law as it would be applied specifically to this defendant. You can just consider the fact that he may be eligible after serving a quarter of the sentence you're assessed, but you cannot say for certain that this is what he's done, because that's determined by the parole board. You have no control over that. We don't know what the parole board's going to do. You can't consider the fact that he may be eligible. I'll just end by saying this: you got it right with punishment. Excuse me, you got it right with guilt or innocence. I have no doubt you'll get it right with punishment. I'm asking you to do just that. Assess the appropriate punishment.
Thank you, Mr. Coleman. All right, ladies and gentlemen, you have heard all of the evidence, the court's charge
for
and
2 to
closing
20.
argument. I'm handing the charge to the bailiff. She will get you settled back in the jury deliberation room where you will begin your deliberations and will be in recess until you reach a verdict.
All right. Let's wait 3 minutes as the jury leaves.
Anna texted me earlier.
I just cannot believe that I heard what I heard. That this jury can consider a prior offense he was charged with, but not convicted.
Before we take a
if
break,
they
also
believe
this
he did
time,
it.
I didn't do it before. Obviously, Mr. Johnson is not in custody, but I am going to revoke any bond amount that is set. There is no bond at this time.
Judge, there's a motion on the tab that we brought to the other case. The aggravated robbery.
Okay, thank you. I'll take care of that.
Hey, I also have these, Your Honor.
What are they?
Oh, it's the election that you asked me to take care of.
Thank you.
And the discovery certification.
And is there attachment with that
Yeah,
certification?
I gave it to Ms. Warner already.
Thank you so much. All right, that's done. That's done. If you'll go ahead and get this kind of filled out, you may wait on the date just in case we don't get there today. But Mr. Coleman, did you have something?
So that's some she needed these that were not admitted into evidence. No, right? They offered and then they weren't admitted.
We don't, I don't think I did.
All right, we'll be in recess till they reach a verdict.
All right. So, Your Honor.
Don't
I'm
go
gonna go
anywhere.
downstairs and pause for a couple of minutes. It's the last time I didn't even get outside before.
Don't be going long. Keep your phone handy.
Don't be gone
I
long.
didn't turn myself off.
You didn't turn yourself off. Now you turned yourself off. Thank you. All right. Revoked bond. So he was out. He was not in custody. I thought he said he was in custody since his birthday. So, court clerk gathering up all the paperwork on that one. Oh wow, what a day! This has been the longest 2-day trial ever. It's just dragging on. It just won't end. Don't like when cases leave a sour taste. I know. Guessing they'll throw the book. I don't know. You had some strong appeals to some religious themes. Let's just say that from the defendant and the defense attorney, and the prosecutor didn't ask for 20. He said put it between 2 and 20. So, they haven't really been. If the prosecutor came out and said, "Look, it's 20 for a reason," if we don't start holding people accountable for this and stopping this crime when we can catch it before there's a shooting, as it was in this case, okay, because there's a firearm and then a shooting happened after. If we can't stop it now, it will result in the shooting. We've got to send the statement now. He could have come out and done that. Josh, that would be you. The defendant is wearing a jail bracelet, and he said on the stand he's been incarcerated since 2024. But the judge said he's not. I understand you're not in custody. I think she misspoke. He has to be in custody. He's coming through the jail door. The bailiffs are letting him in. He's got to be in custody. Which means this, that if he's been serving time since 2024, he may have already time served. He may get time served all the way up to now and have 2 years of time on, like actual service time. Whether or not that's good time or good behavior, I have no idea because we haven't heard about that. Probably not because of the jail calls. But if he's done 2 years and they sentence him to 2 years, he could still walk today on time served, or in theory, depends on how much of 2 years he's actually done. I did notice that when the defendant was talking about what he and his brother did out on the streets, and they gather up the youth and they do this, he couldn't remember the name. Put guns down, pick the gloves up. I think he called it guns down, gloves up before, and he had to look up to remember what it was. That part's not convincing me. That he's all about hey, let's box. Not fire off our Pew pews. But if he was acquitted, why didn't he get released even for a little bit? Because they immediately charged him again as a felon in possession of a firearm. Are you going to set a timer? The timer's going. Sorry, let me put you on there. Timer's going. You've got 5 minutes. 5 minutes in. Doesn't he have another robbery charge still to come? Gabby, I don't know. It sounded like they talked about so many charges, and there was like paperwork and discrepancies as to who was who, and some of them were like that was somebody else, and I don't know. I don't know. If he's still got a pending aggravated robbery charge, that's a big deal. It goes against what he said, where I've never been even charged with an aggravated robbery on the stand. So there is still a pending charge. We need to do a mac and cheese case, please. Oh, red pen. Or a Taco Bell case. Both of those in the news, and also in Mod Chat right now. With the let's see, the mac and cheese case involves Chick-fil-A, with one employee purchasing mac and cheese himself at the register and then refunding that purchase back to his credit card. Not sure how that worked exactly, but they say that he stole $80,000 from Chick-fil-A from one store. 800 times. That's a lot of mac and cheese. I mean, that guy must be putting it away. I had mac and cheese for lunch. I didn't know refunds were an option. So, anyway, we've got that one. You've got the Taco Bell, which is the little tweet I sent out this morning, asking Taco Bell to just clarify their free drinks policy on the refills, because, live mas. You want to at least live long enough to finish your drink. And that may be, may not happen, depending on which store you're at, if that employee still works there that drew a gun and shot one of the customers because of the drink they were getting. Let's see. No solo cups. 80,000 in mac and cheese. 800 times. Hang on. Do the math on this one. That's not mathing very well. I'm just going to say 80,000 divided by 800. That's $100 of mac and cheese per order. Is he catering That's a big order of mac and cheese. That or the price has gone up a lot since I ordered it last. That's a ton of cheese. Even Chester would be impressed. Jody Callahan said, this has been a great case to watch because it shows how a judge can change the law right from the bench. I'm not saying he's not guilty, but so much to appeal. Jody, I agree. I think this guy is... I wish the defendant was a nicer dude that I could stand behind and say, this guy is... He's one of the good guys. I don't get that feel from him. Unfortunately, I still think that my analogy that I've used before, you can't use a bad process to get to a good result and call it good. You can't. And when it comes to justice, you can't bend the rules and then say the result was fair. And I think they bent the rules. Hey, Will Podcast, member for 25 months, says 25 months, been here since Daryl Brooks was only allowed to have an inside ink pen body. Let's go. Yes. OG. Hey, Well Podcast, I'm sorry I had to push you off the phone the other day. We had our court watcher, who may also be calling in right now, or very soon. Facts are facts, no prior bad acts. Yeah. Hey, well, I don't know if you heard that. I'm struggling. I'm struggling with what I heard the judge say in the instructions to the jury. By the way, my camera is just so dark. She said to the jury that during this trial, you may have heard evidence that that the defendant committed an offense for which they may or may not have been convicted. If you feel, if they were not convicted, okay, for which they have not been convicted, not may or may not, they have not been convicted. If you feel that they did commit that crime, you can consider that in this case. This defendant was charged with murder and acquitted in this courtroom with this judge, same prosecutor. That's why they filed this next charge immediately after he was acquitted, like same day or next day. That literally tells the jury that you can consider this murder charge, which they did hear about in the testimony. And, well, they are important. You can consider that murder charge. And if you think he did it, you can basically punish him for it now with this charge. I don't understand how. Is an acquittal not an acquittal? How is that not double jeopardy? If you get to rethink about that case that you heard about, which you didn't hear all the evidence, but you think he did it, you can consider that with this. Should we rewind and hear it again? It's a good idea. Let me see if I can find it. Hold, please. Judge West, where were you at? Let's go back a little bit. Let's see what she was doing around here.
Will be granted. It cannot accurately be predicted how the parole law and good conduct time.
Because you
It was after that.
Okay. The parties will soon present final arguments.
That was after this. We might speed this up.
All the evidence admitted before you. This includes the evidence admitted during the first stage of the trial concerning the defendant's guilt, as well as any evidence admitted during this punishment stage. The evidence consists of the testimony and exhibits admitted in the trial. You must consider only evidence to reach your decision. You must not consider, discuss, or mention any other thing that is not evidence in the trial. You must not consider or mention any personal knowledge or information you may have about any fact or person connected with this case that is not evidence in the trial. Statements made by the lawyers are not evidence. The questions asked by the lawyers are not evidence. Nothing I have said or done in this case should be considered by you as my opinion about the facts of this case or influence you to vote one way or the other. You should give terms their common meanings unless you are told in these instructions that the terms are given special meanings. In that case, of course, you should give those terms the meanings provided in the instructions. While you should consider only the evidence, you are permitted to draw reasonable inferences from the testimony and exhibits, if those inferences are justified in the light of common experience. In other words, you may make deductions and reach conclusions that reason and common sense lead you to draw from the evidence. You are to render a fair and impartial verdict based on the evidence admitted in the case under the law that is in these instructions. Do not allow your verdict to be determined by bias or prejudice. You may, if you wish, examine exhibits. If you wish to examine an exhibit, the foreperson will inform the court and specifically identify the exhibit you wish to examine.
Skip ahead a little bit.
Each juror has one vote, including the foreperson. The foreperson must supervise the voting, vote with other jurors on the verdict, and sign the verdict sheet. While deliberating and until excused by the trial court, all jurors must follow these rules. 1. You must not discuss this case with any court officer or the attorneys or anyone not on the jury.
I think I might have missed it.
Commit that wrongful act. Those of you who believe the defendant did the wrongful act may consider it.
There it is. Okay. Pause now.
You must arrive at the amount of punishment by full, fair, and free expression of the opinion of the individual jurors. You must not decide punishment by lot or by chance. For example, you may not agree beforehand to be bound by the result of a procedure by which each juror gives the number of years the juror thinks should be served. These are then added and the result is divided by 12.
Okay, listen carefully.
To reach a verdict, all 12 of you must agree. Rules that control deliberations. You must follow these rules while you're deliberating and until you reach a verdict. After the closing arguments by the attorneys, you will go into the jury room. The forepersons should conduct the deliberations in an order.
It's still back there.
Discharged, everything that you're dealing with is being cleared up.
It was right there.
No.
No.
I read the charge and then you argue because y'all talk about the parties will soon present final arguments.
It was after that.
As the jurors, you review the evidence and determine the facts and what they prove. You judge the believability of the witnesses and what weight to give their testimony.
It's after this.
In judging the facts and the believability of the witnesses, you must apply the law provided in these instructions. In determining the sentence to be imposed on the defendant, you may take into consideration all the evidence admitted before you.
Okay.
This includes the evidence admitted during the first stage of the trial concerning the defendant's guilt, as well as any evidence admitted during this punishment stage. The evidence consists of the testimony and exhibits admitted in the trial. You must consider only evidence to reach your decision. You must not consider, discuss, or mention any other thing that is not evidence in the trial. You must not consider or mention any personal knowledge or information you may have about any fact or person connected with this case that is not evidence in the trial. Statements made by the lawyers are not evidence. The questions asked by the lawyers are not evidence. Nothing I have said or done in this case should be considered by you as my opinion about the facts of this case or influence you to vote one way or the other. You should give terms their common meanings unless you are told in these instructions that the terms are given special meanings. In that case, of course, you should give those terms the meanings provided in the instructions. While you should consider only the evidence, you are permitted to draw reasonable inferences from the testimony and exhibits, if those inferences are justified in the light of common experience.
Here we go.
In other words, you may make deductions and reach conclusions that reason and common sense lead you to draw from the evidence. You are to render a fair and impartial verdict based on the evidence admitted in the case under the law that is in these instructions. Do not allow your verdict to be determined by bias or prejudice. You may, if you wish, examine exhibits. If you wish to examine an exhibit, the foreperson will inform the court and specifically identify the exhibit you wish to examine. Only exhibits that were admitted into evidence may be given to you for examination. Certain testimony will be read back to you by the court reporter if you request. To request the testimony be read back to you, you must follow these rules. The foreperson must make the request in writing and sign it. That request must, 1, state that it is requesting that testimony be read back. 2, state that you have a disagreement about a specific statement of a witness or a particular point in dispute. And 3, identify the name of the witness who made the statement. The court will then have the court reporter read back only that part of the statement that's in dispute. During the trial, you heard evidence that the defendant may have committed wrongful acts that did not result in any criminal charges or that did not result in criminal convictions.
Did you hear that? Did you hear that? During the trial.
Dispute. During the trial, you heard evidence that the defendant may have committed wrongful acts that did not result in any criminal charges or that did not result in criminal convictions.
That's the murder.
You are not to consider any evidence of any particular wrongful act unless you find beyond a reasonable doubt that the defendant did, in fact, commit that wrongful act. Those of you who believe the defendant did the wrongful act may consider it.
Boom.
You must arrive at the amount of punishment by a full, fair, and free expression of the opinion of the individual jurors. You must not decide punishment by lot or by chance. For example,
That is nuts. That is crazy. We're waiting right now for back to the live stream. Now we're waiting for the court to come back on live, as the jury does have a question. They're 14, 15, 16 minutes, 16 and a half minutes in. They've got a question. It blows me away. If you think he committed this wrongful act for which he was tried but not convicted, then you can consider it. That is bad. That is bad. All right. And for which you haven't all heard the evidence. She did say that you can't consider it unless you've reached the beyond reasonable doubt on that charge. I don't know what'll get a jury to that. But they found it was a firearm without knowing anything about what it shoots or if it shoots. So it's possible. It was bisected, I thought. Wrongful act can't consider, but the act that was acquitted can consider. She did say you can't consider it unless you feel he did beyond a reasonable doubt. And those of you who feel that he did it can consider it. That's what she said. Guys, never go to Texas until they fix this. We're waiting for everyone to come back to court, and the judge will turn on the cameras. They'll probably all be seated there before the camera comes on, just because that's what it is. Thank you, by the way, for Texas Ann for letting us know there's a jury question. The judge also misread some of the things about what you can't do and what you can do, as far as you can't each have a predetermined amount of time and add it all up and divide it by 12 or something. It sounded like she missed something there, and two sentences got combined as well. George was looking better by the day. Stacy, you missed the summary on this one. We've had one verdict. We're now waiting for the sentencing verdict, which will happen any moment now. Do I have to change my vacation to Fulton County? It might be safer. Yeah. It's a crazy little trial. Let's give them just a couple minutes to get in position. Texas says, hang on, I live in Texas. You do. We're waiting for everyone to get back to the courtroom. Then they're going to probably let Tex Ann, our court watcher, back into court, as well as turn on the cameras, and we're going to hear what this jury question is. I would be very, very curious if the juror question has to do with that same area we've just been discussing. With we're supposed to consider the murder? Or, is that double jeopardy? I'm very curious about that. Wonder if that stood out to them. Okay. She said any felony offense. I looked up the law portal in Texas. Everything the judge did is correct. Are you talking specifically about the wording? Because it may be a standard jury instruction. I'm just saying that in this particular case, that standard instruction, which I think was designed to handle the underlying felony case, which is a predicate for the charge. In this case, there's another charge which also fits in that same category, which I think the jury may misunderstand to say they can consider. But the wording says if they weren't an offense that they were not convicted of, if you think they did it, you can consider it. Laura's like, I need more sleep before I can figure this one out. She did specifically mention acquittal. I could go back and play it for you one more time if you want. Let's see.
In any criminal charges or that did not result.
Here we go. Ready?
Specific statement of a witness or a particular point in dispute. And 3, identify the name of the witness who made the statement.
We'll watch this one more time.
The court will then have the court reporter read back only that part of the statement that's in dispute.
Listen carefully.
During the trial, you heard evidence that the defendant may have committed wrongful acts that did not result in any criminal charges or that did not result in criminal convictions.
That's the murder.
You are not to consider any evidence of any particular wrongful act unless you find beyond a reasonable doubt that the defendant did, in fact, commit that wrongful act. Those of you who believe the defendant did the wrongful act may consider it. You must arrive.
I don't know how else to hear that. This is punishment, not guilt. Double jeopardy is for guilt phase. I think that's the difference. Josh is purposefully trying these court cases, finding these court cases for us, so we can think Georgia is better. I think I'm overthinking it. It's possible, Northwest. I may be. I can't think of any, even for sentencing. I don't think of any sentence enhancer which would legally allow you to include things that you were found not guilty of to enhance your sentence. That just, here we go. The court's coming back in. We have a question. Jury has a question.
Don't miss the forest for the trees.
I'm seeing a lot of trees right now. Mr. Wilkerson is packing up.
Either one.
That's the
All right,
question.
but the record reflects state's attorneys present, defendant and defense counsel are present. I've received a message that the jury has reached a verdict on punishment. You can bring the jury in.
It's a verdict. It's a verdict. Again. took 2 minutes less or fewer, took 2 fewer minutes to decide the verdict than they did the actual guilt in this trial. So altogether, if you add up all the deliberation time on this jury, you have half an
Let the record
hour.
reflect the jury seated, state's attorneys present, defendant, and defense counsel are present at this time. I'll ask the fourth person, has the jury reached a verdict on punishment?
Honorable there.
And is it the unanimous decision of all of the members of the jury?
Yes, ma'am, Your Honor, it is.
Thank you, sir. You can hand it to the bailiff.
All right, they're handing the verdict to the bailiff, bailiff to the judge. Judge reviews it, make sure it's filled out properly.
Mr. Johnson, we, the jury, having found the defendant, Romeo R. Johnson, aka Romeo Randolph Johnson, guilty of the offense of unlawful possession of a firearm by felon, find that the accusation of a prior conviction has been proved true. We assess the defendant's punishment at imprisonment in the Texas Department of Criminal Justice for a term of 15 years and no fine. You can have a seat. Does either party wish to have the jury polled?
State, Your Honor.
No, Your Honor.
All right, thank you. And so, is there any reason at this point not to pronounce sentence?
Not from the state, not from the defense.
All right, Mr. Johnson, then at this time, in conformity with the jury's verdict, I sentence you to a term of 15 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've already been in custody that the law gives you the right to receive. You can have a seat, sir. I've handed you 2 things already. The first is the trial court certification of your right to appeal. Obviously, this was not any type of agreement. You have a right to appeal. Mr. Wilkerson will talk to you about that. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you, obviously. If you have questions about the laws that make you ineligible to possess a firearm or ammunition or about how long that lasts, you can also talk with Mr. Wilkes. At this time, I'm going to remand you to the Jefferson County Sheriff's Department until transportation to the Texas Department of Criminal Justice. And ladies and gentlemen, at this time, what that means is that the case is over. I'm going to let them kind of get out of here for a second. I'm going to come visit with you informally just for a few minutes. You'll be released from your instructions that you were previously given. We all appreciate your time. Thank you, Mr. Coleman, Mr. Smith. Thank you, Mr. Wilkerson. And at this time, you can take Mr. Johnson to the back.
All right.
And court will be in recess. If everyone would please excuse yourself from the courtroom.
All right. Everyone excuse yourself from the courtroom. And we're done. Let's see. This is just a great time to point out that that every state is a little bit different. And because of that, be mindful where you commit your crimes. In Texas, the jury decides. The jury decides a lot. What the law, the way the law is written for this defendant, he will have to serve a minimum of 3.75 years before he's eligible for parole, which could mean, with 2 years of time already on his card, that he has less than 2 years to serve for this crime. So 15 years sounds like a lot, but if he's good, if he doesn't cause problems in prison, he probably will be out after 2 years. And honestly, a felon in possession of a firearm, with a record like that, and only getting 2 years, I don't feel bad about that. What I feel bad about is that it might be 15, which seems too much. 15, more than what the jury initially, when they first came into this case, were told there would even be an option for them to go that high. They were told 10 was the max. It was going to be 2 to 10. But they got that additional qualifier because of the priors. And I guess this is a lesson that crime does not pay. Does not pay. Before trial in Texas, defendant chooses if judge or jury will decide the punishment. I think Northwest, honestly, just between me and you, I think he chose wisely, because I think he would have had 20 if he went with the judge. Right or wrong, I think that's where it would have gone. All right, that wraps up this day of trial at 6 o'clock already. I'm finished in time to take my kids to their activity tonight, which is wonderful. Y'all are
Remember in
finished.
the beginning when we started 110 years ago?
It was 110 years ago, exactly. This is the longest short trial we have ever watched. It's been a long one. We're learning about the laws in different states, and obviously there are a few things about this one that just don't sit right. They get stuck in me craw, if that's a phrase we can use. But what we do know is a life of crime leads to a life of time, and our defendant here has picked up some more time. So this is justice, and you got to watch it happen. You guys, tonight when you go home, please hug the people you love. Smile at them. Smile at someone. Smile at everybody. Make their day just a little bit better. And please stay safe till we go live again tomorrow. We're going to try to pick up a couple more court cases because the case that cannot be named, Caleb Flynn, got pushed. Got pushed another 21 days. It's 3 more weeks out. We need to find something else. I know we've got a couple suggestions. We really can't do much. Like if we're on day 8 of a trial, it's already going on, we're probably not going to be able to pick that one up. But if you see something coming up, let us know. Send it to the burner phone. We'll do a little homework. I'll see if the mods want to do some homework. I don't think they should do any, but I'm getting to a smile at my sweet hubs right now. Red Pen, you do that, and thank you. Good call today on the verdict. You were right. I was wrong. I'll say that many more times, I'm sure. We have something new in store for Monday. Yes, I believe this is going to be Judge Boyd's trial. Double murder trial out of San Antonio, Texas. So good work. You guys are amazing. Thank you very much. This is the best place to watch true crime, and it's because of you. Thanks all for making this happen. We'll see you guys tomorrow morning. Get some rest. Bye-bye.